We have filed affidavit of opposition yesterday, madam. That affidavit of opposition may be requisition, my lord, before taking effect. Item number 9.
That is a faithful listening to writ petition for withdrawal.
Lordship, I beg to mention item number 21. And for the petitioner, your lordship, we had filed an additional affidavit in the matter, requesting your lordship to direct calling of the record.
May I please, Lordship? With the consent of the other, I beg to mention item number 33, Lordship. Sir, kindly adjourn for today, Lordship.
Yes. $33.
33. May I adjourn for today?
Infrastructure.
No, adjourn for today, Lordship.
Why?
Some personal difficulty, my senior has some personal difficulty. Today only for
You have taken the consent of the
yes,
other.
Lordship, yes.
Item number 33 to be listed after 6 weeks at the request of.
I beg to Lordship. I beg to mention item number 34, Lord. 34, Lord.
Yes.
Landed close the picture SI account out of for personal difficulty. This is the better
You have taken the consent.
Lordship. He informed
Next.
May I please, your lordship? Lordship, with the consent of the petitioner, I beg to mention item number 35 of today's list, lordship.
35.
35, lordship.
Okay.
Lordship, appearing counsel, we are for respondent number 6, lordship. Appearing counsel, lordship, Esumwa is suffering from severe dental problem, lordship. Lordship, kindly adjourn this matter for today.
Taken the consent
Lordship, she is from petitioner.
at the request of the learned council.
Kindly may I pray to take up this matter of 29th, Lordship?
Why?
Because we have an urgency, Lordship.
And why have you given the consent?
So only medical grounds, Lordship.
At the request of the learned council for the petitioner, matters can adjourn to be listed on 6th of December.
6 December, not possible, Lordship. My senior will be out of the station because there is a constitutional
4th,
bench.
4th of December,
4th or 3rd or 29th.
29 not possible. 11,
Lordship, 30.
15th of December.
Next, Lord. I beg to mention item number 13, Lord, with the complaint of other side.
30,
30.
Yes.
31.
31.
31.
Yes.
I'm paying for accommodation for a week, Lord.
You've taken the consent.
Yes.
The request to the learned council for the petitioner matters can adjourn to be listed after 6 weeks.
Please, Lord. Lord, you were back for listing of a red petition. On it may be taken up on Friday or not.
Why?
As per your Lordship.
Why? Why should this court fix it?
Oh, the Lordship, as per your
You go to the registry. Why? Why do you want the matter to be? Why are you mentioning the matter?
The matter relates to a subsidy matter and the
What subsidy?
thing, your Lordship, investment subsidy. Investment subsidy.
We'll have it on 4th of December.
Obliged. Mr. Lordship, you have filed affidavit in reply yesterday, Lordship. May we allowed to call for the record, sir?
You want to bring on record the
Record,
affidavit?
Yes. I'm obliged, sir. May I please, I beg to Mr. for listing of a rate petition matter. Not any day next week, but
Why?
alert the matter parties to the non-payment of contractual bill matter. Notice is issued on 9 October, matter. 1 month already, we have taken this step. It is not listed.
Non-payment by whom?
Non-payment by GNC, my lord. We have some promise has been installed, my lord, under the GNC.
We'll have it on 11th of December.
Obliged. I am praying for listing. The matter is relating to compensation as per the insurance policy, Lord. By
Compensation as per
insurance policy, Lord. Insurance policy.
insurance.
So I am saying petition against the order of enforcement.
Has the service been complete?
So service complete, I have taken step after that.
No. Take it out. Whether the service is complete, then only this court will fix. And otherwise, if this court fixes the matter without the service being complete, it makes no sense. Find it out. Next.
May please your lordship back to mention for item number 49 of today's daily.
Hmm.
This matter pertains to the settlement of fisheries. On the last occasion, last order, according to the last order, notice was issued. Lordship, today my senior was about to appear in this matter, but due to some personal inconveniences, he couldn't appear, so I pray for adjournment.
Okay, at the request of the learned counsel for the petitioner, matters stand adjourned to be listed after 6 weeks.
Yes. Later become the third person.
Going to withdraw?
Yes, sir.
The learned counsel appearing on behalf of the petitioner, Mr.
Is there, sir?
Lorenzo, submits that he has instructions to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. The interim order dated 3/8/2022 passed by this court stands vacated.
Right.
At number 1 for motion.
Yes, sir. Regarding that non-payment of contractual bill, non-payment of contractual bill,
How much?
that amount is 23 lakh 1400 929. There was article in the NRT process issued on 20 February 2020, and exact 2. And after supplying of all the materials, I submitted the bill, and thereafter it is pending.
Yes, Mr. Roy.
Lordship have to obtain the instructions first.
What instruction? You verify whether he is entitled or not. If he is very entitled, pay.
Lordship.
Matters can be disposed of unnecessarily, troubling you.
Lordship.
Huh?
Lordship.
Dispose it of.
Lordship.
The instant writ petition has been filed by the petitioner, claiming an amount of rupees 23,14,929 from the respondent authorities on a respondent authority. The facts as enumerated in the writ petition is that the petitioner is in the business of printing and supply, business of dealing, is in the business of printing as well as supply of various electronic and stationery materials to the various various departments of the government. Pursuant to a tender process initiated on 22/2020 for supply of stationery for the year 2020-21 by the respondent's office, the petitioner made supply to the respondent authorities However, the petitioner is yet to be paid the said amount for which the petitioner had submitted representations to the respondent authorities on 16/9/2022 and 31/5/2023. It is a further case of the petitioner that as the petitioner have not received the amount in spite of submitting the representation, the petitioner is before this court seeking for a writ of mandamus directing the respondent authorities to pay the amount of rupees 23,14,929. I've also heard Mr. S.S. Roy, the learned government advocate, appearing on behalf of the respondents, who submits that as to whether the petitioner is entitled to any amount submitted that as to whether the petitioner had made the supply or is entitled to any amount can only be ascertained after making necessary verifications. And as such, a direction may be issued to the respondent authorities for making necessary verifications. And if it is found that the petitioner is entitled to any amount, the amount claimed or any part thereof, the respondents be directed to make such payment. Taking into account the above facts, as appears from the writ petition and as well as the submission of Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents, this court disposes of the instant writ petition with a direction to the whom?
Lordship,
Direct the
the deputy, district commissioner, Lord.
Huh?
District commissioner, Kamrup, Amingaon.
where is the district commissioner is nowhere a party here.
Oh,
You don't know
the
for whom
deputy-
you are representing.
Lord, sorry, Lordship, deputy. The second.
Goodness. Directing the Director General of Police, Assam, either by himself or through his delegate, make verification as to the entitlement of the petitioner. And if it is found that upon verification that the petitioner is entitled to any amount, the amount or any part thereof, the same be released to the petitioner. The said exercise be completed within a period of 6 months from the date a certified copy of the instant order is served upon the Director General of Police, Assam.
May please, Your Honor. So the matter is pertaining to non-releasing of performance security money loss deposited by the petitioner against the contractual work loss. So in this case, petitioner has completed the construction work loss as per work order dated loss 11/1/2021. Page number 15 and Excer 1.
Performance security,
Yes, Lord.
who has taken it? Madam, you are appearing for whom?
1 to 3, Lordship.
Who has taken the performance security?
Lordship, as per Lordship work order, petitioner has deposited the performance security money amounting
To whom?
before Lordship in the industrial cooperative bank limited Lordship. Annexure 2 Lordship, page number 20 Lordship.
No, to whom? Industrial Cooperative Bank.
Yes, Lordship.
You have deposited the security deposit,
Yes,
and from there you are to entitled to amount.
Yes, Lord.
Is it?
Lordship, as per work order Lordship,
Issue notice making it returnable on 3rd of January 2024. Mrs. RDB appearing on behalf of the respondent numbers 1, 2, and 3 duly accepts notice on behalf of the said respondents. The petitioner is directed to serve extra copies of the writ petition upon Mrs. RDB by 24th of November 2023. As regards the respondent number 4 and 5, the petitioner is directed to take steps by way of registered as well as usual by 24th of November 2024. 23. The learned counsel, the case of the petitioner herein is that the petitioner had, in pursuance to a work order issued by the respondent number 3 by the Industrial Cooperative Bank Limited, had deposited a security deposit. It is a further case of the petitioner that even after the completion of the work, the said amount of rupees 1,60,000, which is the security deposit, is still not being released, for which the petitioner has approached this court. The respondents are directed to apprise this court on the next occasion, on the next date, as to whether the petitioner is entitled to the refund of the said amount, and if so, as to when the said amount would be disbursed to the petitioner. Hmm.
Similar to MTEL. Here in this case, that the petitioner firm was engaged for writing manually in return card for the beneficiary data Miller.
I mean, Amingao Milot and Rongyam. In this case, Milot, though budget has been allocated, but same was not released.
Huh?
Budget has been really allocated, Milot, in this case.
Where is it?
Milot, page, Milot, 14 Milot. Annexure 4. Milot.
Page 14.
Yes.
This is your bill.
Yes.
Then Deputy Commissioner says that the amount is, now they have revised submitted a revised bill amounting to rupees so and so. As such, fresh bill submitted by IA is forwarded to you for payment. Payment of writing beneficiary detail of new ration card.
Yes.
Now the sanction has been granted by the Director of Food and Supplies, and the payment has not been made
Yes.
to you. That's it. When was the sanction made?
Milot.
22/7.
Budget has already gone.
Gone.
Why were you sleeping?
Milot, my representation was already Milot, pending before this. Morning.
Your representation, you gave it only in the month of October.
Milot,
Where is the earlier representation? Show me.
Milot,
You have not enclosed.
before that, Milot,
Then
official Milot visit was there.
you approach on 410 and then immediately rush to the High Court.
No, Milot.
Fantastic.
Frequent visiting is also there. Visit the office, Milot, but they are saying that it will
Ah.
very soon.
Have you at all given this representation? Where is the receipts?
No,
Milot, communication was there, Milot. I have pleaded Milot in the WBC. Milot. That frequent visiting is off.
To dispose it of. The instant petition has been filed by the petitioner claiming an amount of rupees and seeking a direction upon the respondent authorities to release the amount of rupees 15,54,935, including the GST payable to the petitioner firm on account of putting beneficiary details on the ration cards by manual writing under the NFSA project. It reveals from the records that the petitioner is in the business of printing as well as supply of various electronic and stationery materials to various departments of the government since many years. And the departments whose on the basis of a communication dated bearing number DS.29/2021/6 dated 2/7/2021. 27. Very difficult. 510. Why you are mentioning about? On the basis of communication bearing number KSL.68/2020/30 dated 5/10/2021, the Deputy Commissioner Kamrup Amingao had engaged the personnel of the petitioner for writing the beneficiary details in the pages of NFSA ration cards under the Kamrup district in legible handwriting using good quality ballpoint pen and submit fresh bills for payment after completion of the work. It is the case of the petitioner that pursuant to the completion of the work, the petitioner submitted a bill on 16/11/2021 of an amount of rupees 15,54,935, which included the GST, which was payable to the petitioner. Subsequent thereto, on 7/1/2022, the Deputy Commissioner Kamrup Amingao had written a letter to the Director, Food and Civil Supplies and Consumer Affairs, Assam, whereby the bill of the petitioner of an amount of rupees 15,54,935 was forwarded. It is the submission of the learned counsel appearing on behalf of the petitioner on the basis of Annexure 4 that the said amount of rupees 15,54,935, that in respect to the amount of rupees 15,54,935 to which the petitioner was entitled to, there was a budget allocation being made for the period from 1/4/2022 to 31/3/2023. However, the petitioner was not disbursed the said amount. Under such circumstances, the petitioner submitted the representation dated 4/10/2023 to the Deputy Commissioner, Kamrup Rural, Amingaon, for payment of the said amount. As the said amount was not paid, the petitioner therefore, in spite of the representation, the petitioner therefore has approached this court by filing the instant writ petition. I've also heard Mr. S.S. Roy, the learned counsel, appearing on behalf of the respondent numbers 1 to 5, who submits that the actual entitlement of the petitioner to the said amount of rupees as claimed can only be made after making necessary verifications by the office of the Deputy Commissioner, Kamrup Amingaon, as well as the Amingaon, as well as the scrutiny being carried out by the Director of Food, Civil Supplies and Consumer Affairs. He further submitted that even assuming that the sanctioned budget allocation was made in respect to the said amount, but the said budget allocation was for the period from 1/4/2022 to 31/3/2023, and as such, the said period being over, it is not known as to whether there was any fresh budget allocation being made. This court have given an anxious consideration to the matter and is of the opinion that the interest of justice would be met if there is a direction to the respondent authorities to make necessary verification, and if the petitioner, and if upon verification it is found that the petitioner is entitled to an amount, the amount claimed or part thereof, the same be paid to the petitioner within a time frame. Accordingly, this court therefore disposes of the instant writ petition by directing the Deputy Commissioner Kamrup Amingaon, as well as the director.
Lordship, Deputy
Because he has forwarded
Director.
directing the Deputy Commissioner Kamrup Amingaon to verify as to the entitlement of the petitioner as claimed, and upon making necessary verification, if it is found that the petitioner is entitled to the amount so claimed or any part thereof, this court directs the respondent authorities to release the payment of the petitioner, to release the amount to which the petitioner is entitled to. This court further directs the Director, Food, Civil Supplies and Consumer Affairs to also do the needful so that the said amount upon be released to the petitioner upon making necessary verifications. The said exercise be completed within a period of how much? 3 months from the date of submission of a certified copy of this order to the Deputy Commissioner Kamrup Rule.
At number 4.
Yes, Mr.
This
Mannan.
matter, your lordship has.
What are you challenging?
I'm not challenging anything. The award was passed by the labor court, giving a reinstatement with full back wages to the work. I have communicated to the workman twice. She did not come and join. Then she filed an appeal, filed a writ petition before the honorable court, challenging the award, saying that she wants a modification of the award on the ground that she wants the wages to be higher, which was paid to her. This court dismissed the state writ petition, saying that you cannot claim the wages for the industrial dispute at that matter, where the issues were with regard to your dismissal from sir. So that was this. She raised another dispute with regard to wages, that is a separate. Now what has happened, a long period has gone. She has never come and joined. We have given letters. Now what has happened, according to your lordship industrial dispute at section 19, the period of award is normally 1 year. So that period was gone. Then the writ petition was filed. Even that period has gone long time. We have communicated with it. Therefore, there is another provision that if we want to terminate the award, we should inform the workman that we are terminating the award because the award has become stale because of the period effects of time. So therefore, we made an application about 3 months back. Now 2 months have also elapsed. She has communicated that same issue. I want higher. That cannot be your lordship. Therefore, I have come that your lordship direct terminate. This is basically. First, if your lordship would like to see the award, that starts from page 35. The operative portion is page 47. It's an old matter, your lordship. Then again, she will come back and then create a problem. 47, page 47, the last paragraph 19.
So it was against the termination.
It was
Dismissal.
against termination, dismissal.
And as to whether she's entitled to back wages.
Yes, we are
Then
ready
what
to pay.
happened?
We were ready to pay the
So you are back. No. But
come and join.
decided from the above, it is found the management is not justified in dismissing him or her, and she is entitled to be reinstated in her service with full back pay.
Yes, we are ready to implement the award.
Have you reinstated?
No, she did not join. We
Oh.
made application. Next page 48 and 49. We have
So
given
you
a letter.
informed him. Inform her.
Yeah, we informed that you come and join.
Asked to join your earlier post of receiving and delivery.
We have said that. Then again, we gave another letter at page 49.
Then
Your lordship,
she approached the
then she
spot.
came by a writ petition that your lordship will find at page 50.
And in the repetition, did she mention about this page 48 and 49?
No.
She didn't say anything.
She said that she want the
you
award.
appeared.
She want the award to be modified on the ground that she want her wages to be higher than which was paid by her. That was the case before this on. The court held that no,
Wages to be higher means?
we were paying her X pay. So and so. He is claiming
No, during that period,
Yes,
for the back
exactly.
wages.
now she came before this court says no, I am entitled to actually a higher wage. And
But
this
wouldn't
court
that be a,
modify the award giving her higher wage?
but wouldn't that be again an industrial dispute?
That cannot be in the same case. It cannot be a same case because there is a provision wherein she can approach the labor commissioner for enhancement of wages. If she is employed, she is given less wages or the minimum, less than minimum wages. She can always pay a payment of wages act. She can raise the provision before the labor. That she did.
And what happens if the levy commissioner doesn't do so?
No, the labor commissioner took up the matter. Then she raised the industrial dispute with regard to her dismissal along with this with her. The court said that the reference which was made by the government to the labor court was with regard to the dismissal part and back with. There was nothing with regard to.
So
the-
that issue was not raised. And she did not thereupon also approach separately.
No, she did not at that time. Then what happened? This court in this page 50 judgment, the last page that your lordship will find at page 61. This court has given her, dismissing the writ petition, has given her the liberty to approach the authority. She approached the authority. That is a separate matter. page 61, last paragraph, 27. However, dismissal of the writ petition will not come in the way of enforcing the award dated and grant of relief to the petitioner in terms of the said award. If the petitioner has any further grievance, as noticed in the award dated trend, it will be open for her to raise a grievance before the appropriate. So that part we are not concerned. But this award remains for a
And-
period. So this award enforceable period is gone here. Para 27 at page 61. I'm not reading the whole because it was dismissed. 26, the petition has been dismissed. 27, she was given the liberty.
What is the reply which was given on 2/9/2013 to your letter dated 19/8/2013?
The same thing, your lordship. Basically, she is saying that I will.
No, why haven't you not enclosed?
Copy is not with me anyway. He has
That
said,
has a vital.
last letter is also enclosed. That is the last page. I have
That I've seen. That is why she is saying that at page 48 and 49, those two letters, she says that I have received one. The second one I have not. But the first one I have replied.
Yes, he replied.
And what course of action have you taken thereafter?
Thereafter, she came before this round court by the writ.
No, this is for enhancement, which is a different
There
aspect
has
to the
come
matter.
before it.
Yes.
She is not saying that I'm not, the award is so and so is bad.
Now you want that this court should give the sanctity
Yes.
to your proposal
Of termination
that
of-
the award had spent its force.
Yes. Because of.
That
section
is why you have before this court.
Section 19. Section 19, 3 and 3
Of
says
the,
of the industrial dispute.
No.
Because an award has also its period here. Now, what happens, your lord? If at all he was given the higher wages in the other your lordship forum, he will come back and say, no, award has to also be implemented on that basis. That will create the problem. Section 19 and 3 and 6. Basically, 3 is the period of award and 6 is the notice to be given to the party bound by the award, intimating the intention to terminate. So we have given that after about that has to be given a period of 2 months.
no. See, once the labor court had held that the award, that your dismissal was wrong,
Yes,
so wouldn't she revert back
Hmm.
and become an employee of your workman under you?
we had no issue.
No,
We
no,
said,
no.
You come back.
Understood. The moment she becomes a workman under your management, can you now say that the award has not become enforceable. It has already, by dint of its content, has already become enforced.
If the award is implemented, if
It,
it is,
it becomes implemented on the face of it, because the order categorically says that the dismissal is bad.
fine.
So without a dismissal is bad, so
Reinstatement
your
with full back.
termination becomes bad.
No, it is reinstatement with full back. We have accepted it. We said you come and join and take your full back.
Hmm.
He said, no, I will not come and join until and unless.
No,
I
you have
feel
no.
I
She
have-
has,
I have
she,
wished.
she has not said that communication is not here before this court 2-9, which is
That
the
is
most
not
relevant
there. No,
document.
the last one is there.
Huh.
The last one is there. Basically the same communication.
Hmm.
That she wanted the higher. Higher wage will come until and unless you are an
No,
employee. of
last
the-
one only says that I was expecting your reply to my communication dated 2-9-2013. What have you done?
Lordship, may kindly peruse page 67, Lord.
Hmm.
Some private respondents approach the appropriate.
Yes,
forum.
that
No,
is
that
what.
is the
That
higher
is another
wages-
proceeding. That is what
Yes,
they are
yes,
trying to do.
that is what the higher wages part I am not saying. I am not coming before your lordship with regard to the higher. This part, this case, how long will we will wait for the,
No, if she doesn't come,
Yeah, she has not come.
no, you have to dismiss her.
again the dismissal will.
No, dismissal has been set aside.
Then-
So you have to again dismiss her. If she is not for whatever the violation of the standing orders or on account of misconduct. If you don't do,
No, no, this is-
how you say that, oh, the award has become, because the dismissal has been set aside.
there is this 19.
19 is different.
19(6) says an award will become terminated on notice. That also is there.
There is another provision no, by which your people can be sent to jail. Where is that? Non-compliant.
Who has not complied?
Kindly see this.
Hmm.
19.6.
Yes, that's what I am referring.
19.6 says that whatever may be, the award shall continue to hold the feet
Yes,
till you give a notice.
yes. I have given the notice.
Now, the moment that you give a notice, she has replied.
Yes,
Then,
2 months have elapsed here.
no,
She
she
has
has
not-
replied. What have you done to this reply on 28/9/2023? What is your decision thereupon? She said that she was waiting for your communication dated 2/9/2013. And that document is the most vital document which is not on record.
the
Mr.
next
Y.S.
paragraph,
Manan, the
Your
learned counsel
next
appearing on
paragraph,
behalf of the petitioner,
everything-
submits that he would like to file an additional affidavit bringing on record the communication dated 2/9/2013, the reference of which have been made in the communication dated 29/8/2023. List the matter again on when? 28, 29, 29.
In the next paragraph, it says that you give me grade 1.
That is a different thing. You may not give. That is absolutely a different thing. You may not.
Hmm.
You may reinstate her, whatever may be. And thereupon, if something happens out there, you can very well say that. But the fact remains, one thing one has to understand. Once the dismissal is set aside, maybe it may not be a case of reinstatement. The reinstatement prayer will go in view of 19.6 at
Yes,
best.
That
At
is-
best.
that is what
But once the dismissal is set aside, what is the consequence?
reinstated.
She's automatically
Otherwise, automatically there.
She's automatically
Yes,
there.
But
So
she-
once she is automatically there, how do you throw her out? The only manner is that some action has to be taken. Otherwise, it will have a far-reaching consequence.
Your lordship is true. That is why we gave the note.
But it is only when it has not been enforced. But by implication, wouldn't that be enforced? And the other action which she is contemplating, for which there has been a delay, that is under the Payment of Wages Act, which will be a separate dispute.
That-
That is, therefore, I was asking you.
That's
Will-
a separate dispute because
you
that I have
will-
annexed.
You file an additional affidavit bringing on record,
Let.
then I can issue a notice.
Much of.
59.
That cattle market on a private property.
Did you get anything?
My lord, there is one,
Yes, what did you get?
My lord, one notification and judgment from our court, my lord, regarding permission from designated expert.
What are it? What notification is that?
It has published under Rule 7 of that cattle preservation rules, my lord. In exercise of power, section under 21. It says
But show me one thing.
my lord.
Without the permission,
Yes. That
one
is
cannot run.
not-
Then
That is not there.
how can you,
It's
how,
only regarding.
you are
permission
making
for-
all these rules.
Yes,
First of all, how do you give up authority on the basis of a rule?
yes.
That I'm not going into that.
my lord.
But the fact that without there being a prohibition, that without a license you cannot.
That license part is not described in the act, ma'am.
My lord,
Yes.
this is one matter, my lord. This private cattle market has been some order passed by not coordinate bench, my lord. Just,
In time order, I'm not bound.
just not in time, but disposed of. Just for your lordship.
But how do you do that? That is the judgment order she's also referring to. Yeah, this is the order. Wherein it is having considered the provisions of the assurance and considering the fact that we have already approached the respondent by way of a representation which is stated in the pending of the considered that instead of keeping the recipient, them may be disposed of with a direction to the respondent to take representation submitted by the petitioner on so and so before him on the board and after constitution of the same in terms which they have disposed of the represented.
Paragraph 7, my lord. And paragraph 6.1, 6.2, lordship may kindly peruse that.
This is a consensus order. And remaining are what are you?
Yes, but paragraph 7, may kindly have a look on. Paragraph 7.
So
Paragraph 7.
paragraph 7, are you going to say that that is binding on this court? That is
No, I
what,
just-
but the fact is, where is the prohibition? And whether, unless there is a prohibition,
My lord, three,
whatever prohibition is on are on other aspects. The prohibition, whichever is given, is different. Where's the Kettle Act? You give me on the last occasion.
yes, I gave a copy to you, lord.
Usman sir.
Three A,
Yeah. Ọসমীয়া Act. এইকেইটা ওপৰত। What is the name of the act? The Cattle Preservation Act.
Act, yes, my, very good. The Assam Cattle Preservation Act 2021.
Ah,
Yes, there's the copy. Okay, sir. Three A, my lord, 3A.
Hmm.
Animal market means a marketplace or cellar or any other premises or place to which animals are brought from other places. That's what. Any other premises, my state act, I'll say, my lord, state act, in the state, any premises means within the state, my lord.
But that particular definition also includes the expression, my lord, as duly licensed.
It is got two parts. First is premises. Second is includes animal affairs such and such as the license recognized under the state act. This is that. These are rules. I'll just take a look to that rules, my.
Now, this is section 10, and I was reading section 10. 10. Let's see the rules. What does it say?
Rules, my lord, yes.
Section Rule 3
My lord,
stipulates
district
that the
magistrate,
district magistrate of the concerned district shall be the prescribed authority to exercise the powers and functions under subsection 3, 4, and 5 of section 5.
Right.
Okay. Now let's see section 5(3). The veterinary officer shall maintain all records of issuance of refusal. What
Yes.
does this have to do? How can the district magistrate exercise the power of the veterinary officer? See, any person aggrieved by the refusal of the veterinary officer in so and so, under so and so, within 15 days from the year so and so, appeal to the prescribed authority. So here, under 4, he becomes the prescribed authority.
yes,
And 5. So this is the for the district magistrate.
yes.
Then
No, my lord,
registration of firm or agency. Competent authority is appointed by the state may issue registration certificate to the agency or firm for the purpose of trading of cattle
but this,
on receipt of.
that was central election rules are given a copy, my lord.
Bona fide animal husband. Now kindly see section 7(4).
7(4), my,
Yes.
yes,
Notwithstanding anything contained in subsection 1, 2, and 3, the competent authority may issue permit for transport of cattle for bona fide agricultural or animal husbandry purpose as prescribed in the rules framed in this act.
yes,
So it is for transport.
transport,
Okay. Now section 7, kindly see. Competent authority is here, so and so, to the agency or farm for the purpose of trading. How does the trading come into the scene again? As regards the genuineness of an application is provided under section 7(4).
yes. They issue permit,
And where is the requirement that an agency has to be registered for the purpose of trading as per the act?
My lord, Rule 7, my lord.
2, 7,
cattle should be transported,
2, 7 is where?
Rule 7, my lord. Another rule.
The rule 7. Can the rule say if the act does not require?
This comes under section 7, my lord.
Hello.
now there's another issue, my lord. There's one central rules I've given to lordship, my lord, 2017 central rules. Just kindly have a look once, my lord.
This one?
Yes.
Yes.
This is made under Prevention of Cruelty to Animal Act 1960. Here, the definition of animal market kindly come to section 2B, my lord. I just want to pinpoint one thing. That's why. this definition and definition of Assam Act, my lord, parameter, same almost.
Then
Now, please come to Rule 12, my Rule 12. So you will find one thing. So why these veterinary people are here? And this is applicable all over India except Jammu Kashmir, this act and the rules. So 12 kindly see veterinary inspector, etc. at animal markets. Now I Rule 12, page number 13.
Yeah.
Every animal market shall have adequate numbers of veterinary inspectors and paramedic veterinary staff to assist the veterinary inspectors authorized by the district animal market committee. The veterinary inspector shall screen the animals before entering the animal market for suspected contagious and infectious disease such as this, my lord, food, all these things.
Hmm.
Next, veterinary inspector shall supervise the
so these are
unloading
the
arrival of,
duties of the veterinary inspectors.
yes.
Then
I
your
want-
case, is it your case that the respondent, number 7, it doesn't have a veterinary
My
inspector?
point is not that. My point is, I'm just telling it, my lord. That's why your lordships, my lord. What happens, my lord? This is it is a registered market. The authorities know that this is a market going on there, my lord. So they can put the veterinary inspector, all these things for maintaining, my lord, these things. This is the important thing. Suppose there's a disease also spreads, they can control. But suppose there is an unregistered market, which government doesn't know. Same type of animals comes here, spreads the diseases, my lord. That's why just for registration, my lord, it is necessary, my lord. So that the authorities will know vehicles are coming, bringing here. Even section, my lord, rule 7 also, kindly just have a look, my lord. There are certain criteria in the same rule.
But rule 7 refers
No,
to
no,
7.4.
No, this one. Same one, so 7. District Animal Marketing Committee monitoring before granting registration shall ensure that all requirements as stipulated in these rules are fulfilled in the animal market. What are these? Ensure that animal market has adequate housing, shade, all these things, parameters are there. I want to humbly submit to your lordships, my lord. This is very important for the society. For the animals also, my lord. That's why so much precaution the government is taking.
No, you may have a case taking into account that, you see, the prohibition here as per the
am-
Cattle Preservation Act, it may not be adequate. But you may have a case that these animal market
Fine, fine.
requires compliance to the mandate of these rules.
I
And
understand.
you may give specific circumstances that these are the rules which have not been followed by them. And as such, the respondent authorities should take steps who are bound as per these rules and stop it.
That's what I just, because what lordship has given us chance to interact, my lord, and give it 2 days time. So thank you, lordships, my lord. Because
No,
of
no,
that, I can
no,
this.
because here the problem with this act,
I understood.
there
Yes, yes,
is no prohibition for trading.
Lordship would like to mean other words, my lord. In the act, one word it is used, I feel accordingly. Any other premises or places, including private, then if that word was there, could have been solved. But Lord develops that way, my lord. First, the law is made, comes before the court, lordship gives the observation,
No, but
it goes back.
you may have a case under this, because here it requires the requirement of compliance of many aspects.
Yes.
Because here it will be an animal market, the horse of anything or not,
Anything, yes.
and all animal markets are required to follow these
They
things.
do, yes, my lord.
So under such circumstances, if they are not doing these, you can represent before the authorities. And if the authorities, they do not, then obviously take it. Isn't that the case?
Lordship is always right by that way. I just want about this order passed by the coordinate bench, my lord. In paragraph 7, there's an observation from the aforesaid provisions of the Act under rules read with notification dated 25/7/20. It is noticed that it is the district magistrate or his authorized representative who has the authority and jurisdiction to grant permission to operate an animal market upon due consideration. This is
Where
all-
does, no, okay, very well. Where in the act it is mentioned that the permission to operate an animal market is by the district authority? Where in the act it is mentioned?
in market, my lord. Page number 58, can you have a look on?
Huh?
Page number 58.
Of the writ petition?
Yes.
Yes.
Now let us see that along with the act letter. Lordship has seen, my lord. 7, 8, and 10. These sections are mentioned there.
No,
Let us
these
see
are the
that clear.
competent authority. I'm not on that. But where in the act it is mentioned for the purpose of trading? It is only in the rules.
Comply with this
Rule
provision.
7 it has been mentioned.
Now, 3A says, except this, including the words private market. But since premises, my submission will be, when it's written there, premises, state act, within the state premises. So it needs duly licensed. That's what my lord. 3A. Difficult is there, my lord. But my submission is, my lord, animal market, premises, place to which animals are brought. Kindly, once again, lordship, look, my lord. Other places or place to which animals are brought from other places. The premises here, the state act, is within the state. My submission is, my lord. Duly licensed.
You see, as duly licensed or recognized under the state or any other law for the time being in force or so and so, then only it becomes an animal market within the definition under 3A.
Yes.
But if it is not licensed, then how do you bring them? That was therefore my specific question earlier also. But however, if we see the definition
Yes.
here in animal market in this rule, it is different. Means a marketplace or sale yard or any other so and so in which animals are bought from other places and exposed for so and so or slaughterhouse and used in connection with or any place adjoining a market using the market so and includes animal fair, cattle ponds where animals are offered or displayed for sale or auction.
Yes.
It does not limit it. Limit the definition to which is there as per our Cattle Act, to animal market will only come which are recognized. That is the difference between this and that. Therefore, this is a much wider definition of 2B, which does not include. Here, it limits only to licensed ones, which is I would say it's a fallacy on the part of the legislature in our state to make it in this manner. If they have not used that as license,
Or recognized.
or they may very well say in another place that there cannot be, there is a prohibition to run an animal market without license. But the thing is, you have reduced the scope of the animal market, saying that it is only those things.
Now, if it says recognized under a state act, it's the same in state act, Assam Act.
But
no, this 3A.
3A, no, recognized means licensed.
Licensed or duly licensed.
Yes, duly licensed. So then only it becomes an animal market.
Yes.
Which is not the case under 2B of the rules, which is completely wide. Any sale made, you carry out any trade of an animal will come within the ambit of an animal market.
That's the way one is come to the court, my lord. Develops. They become smarter now once. That's the way it develops, my lord. Every law will fight, my lord. This is the first act. In all over India, I think Assam is the first or second state. I have not seen other states like that.
Which one?
This state act
Hmm.
about the cattle. Because of the Bangladesh border. Every morning you open the TV, you can see.
That
Yesterday,
is why Section 7 mostly says about transportation. It does not say transportation within. Only see Section 7. Whereas the rules say
no person should transport cattle. Yes, it's the transport.
any place of the other state to Assam to any place outside state.
Hmm.
Any place within the state of Assam to any place outside the state where no person shall transport or offer for transport or cause to be transported any cattle from any place of other state to any place within state. No person shall offer for transport so and so any cattle from any place within the state to any other place within the state, the slaughter. Then again, the slaughter where it is punishable. Again, reducing it, the scope. Can you see this?
Yes.
So this prohibition is against the transportation for slaughter.
Just take a look once, animal market regulation 10, rule 10. Once again, just
Which one?
of this same act, section 10. Every animal market for recognized every animal market committee for recognized animal market.
So that is what I'm saying.
That-
Animal market has been reduced only to those which are legally recognized. Or legally, what do you call the term used? Licensed or recognized under the state act.
Yes.
Which is otherwise the case in respect of the rules. Those rules. Those rules makes it clear. Any animal market.
They should have been in the line of this central act rules.
No, I
Should write
think
that way.
because here your basic case is without the permission, how they are running.
Yes, that's one. And number two, they have used the lordship's writ petition numbers in the receipt and threatening the officials. Don't come near me. There's a high court behind me. See the my lord. Very tactful they have done it, my lord. That part lordship shall have to look into, my lord. I feel
Anyways, we do one thing, we'll issue notice,
my lord.
but there is no stay. Without hearing them, it doesn't arise.
Or lordship may
But
do
don't you think that you should develop it on the basis of that rules? Your case.
authorities. State. Even my lord, very fastly I discussed with them. One word is missing in the rules, including private. I discussed with my
And or if that word is not there, duly licensed or recognized, should have included everything.
lordship do one thing. Since lordship is pleased enough to my kind enough to issue notice, my lord. Lordship also issue notice on the interim period for the next time. Just lordship is not
What in time prayer?
to consider for interim period next time. Not today. Let them come forward. That much, my lord. I will not trouble your lordship.
But why don't you make your case better by approaching the authorities, stating that you see these rules? Why don't you bring these rules, which will help you a lot?
Lordship, I think lordship may keep this at least for the time being. Let us also
With
get
these,
we also get educated, my
without
lord.
these rules, I don't find a
In
case for
every
interim.
day's, my lord, in every day's proceedings, we also get educated, my lord.
Okay. And apart from that, you have also to satisfy this court on the question of locus.
That paragraph, we are page 12, I'll show next day, my lord. The next day I'll make it.
Then
I'll make it.
this court is yet to be
32 lakhs I have
satisfied.
paid in a person running illegally.
Rice mill. Have you seen the judgment in
Rice mill.
1971? The Supreme Court says that once you are operating a rice mill, you cannot say that that other rice mill is violating. And because that will be his right under 19(1)(z) will be violated. You cannot say
91G,
that.
yes, 91G.
You can't become a person.
And another thing, my lord, whatever the cattle market cases I came across, I only find you 50, 55 before the 68 came to courts. I checked up all before 1955, 52. Anyway, my lord.
Issue notice making it returnable on 20/12/2024, 23. Mr. N.K. Debnath. No, yeah, whoever. You are appearing, Ms. M. Bormon appears on behalf of the respondent number 1, 2, 3,
Yes.
and 7. Mr. N.K. Debnath appears on behalf of the respondent number 4, 5, and 6 and accepts notice. As notice in respect of respondent number 1 to 7 have been duly accepted by the councils, extra copies of the writ petition be served upon them by 24/11/2023. As regards the respondent number 8, steps be taken by way of registered as well as usual by 24/11/2023. This court further grants the liberty to take steps against the respondent number 8 by way of Dusty and routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is a lessee of a market namely Sheurar Vita Janapriyo Ansalik Guru Bazar for the period from 2020 for the period from 1/7/2023 to 30/6/2024. It is the case of the petitioner that although the petitioner herein is the lessee, but his business has been affected by the respondent number 8, who is carrying out a private cattle market. Which that too, in violation of the provisions of the Assam Cattle Preservation Act 2021 and the rules framed therein under, which stipulates that there is a requirement of taking certain permission for the purpose of trading in the cattle market. It is the further case of the petitioners that the private respondent not only have not taken the permission from the authorities as per the Assam Cattle Preservation Act 2021, read with the rules framed therein under, but have also used the name of the petitioner, used certain orders, have also mentioned in their receipts about orders passed by this court which have no relevance, which has no relevance, and thereby the people in general people and the authorities in general have been deceived. It is therefore the submission of the learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the petitioner, Mr. Emnath, that the further trading activities carried out by the petitioner, respondent number 8, without any permission, and that too by deceiving the people and the authorities, ought to be restrained till the disposal of the instant writ petition. This court have perused the orders passed by this court. The orders passed by this court in WPC number 3626/02, WPC number 2999/14, and WPC number 4440/2022 does not reflect that there is any direction passed by this court, thereby permitting the private respondents to carry out their business, the cattle market. What the orders reveal, or orders in the said writ petitions reveal, that the respondent, Panchayat and Rural Development, and its functionaries have no say in the regulation of private market of the private cattle market. This court have, however, taken note of that the respondent number 8 is presently carrying on their business, and without hearing them, any interim order would, if passed, it would be it would not be in the interest of justice. Accordingly, this court is not inclined to pass any interim order ex parte against the respondent number 8. The interim order, the prayer for interim order shall be only considered upon, no, the prayer for interim order shall be considered after due service effected upon the respondent number 8. None appears on behalf of the petitioner on call. Pursuant further to that, there has been no affidavit filed in pursuance to the order dated 18/11/2023. For the end of justice, this court fixes the matter again on 29th of November 2023.
Lordship, petitioner was Lordship ex lessee 2021 to 2022. Lordship, bid price 20 lakh 786 rupees, my lord. I have challenges annexer 9, letter dated 13/3/2023. It's from 38.
Page
48.
yes, then
Then Lordship, authority passed by order, Lordship, close date only COVID pandemic 18 days. My lord, I view what is 90 weeks, Lordship. That means 90 days.
so you have been disqualified.
Calendar and annexer,
You have been disqualified.
no, Lordship.
What are the
Lordship. Balance amount, Lordship.
understood? Disqualified for what?
Lordship, I'm ex-lessee, Lordship. Defaulter.
So you say that you are actually liable to pay only 4,47,000,
Yes, Lordship, yes.
but they are asking you 10,26,000.
Yes,
That is it.
yes, Lordship.
But they say that if you don't pay, you will be disqualified.
Lordship.
Have you been disqualified? So this communication is of 13th of March. We are in the fag end of this 2023,
23, yes, Lordship.
and you are challenging now. Why?
Lordship, I am challenging, Lordship.
The petitioner couldn't get hold of anybody. and was trying to locate you. Yes, tell me. Why? You are approaching this court after 8 months.
Your Lordship, not participate to 13/3/2023-24.
You are entitled to remission for the entire amount.
Remission, 25% remission only. Authority. I want to 100% remission. 100% remission. I want.
Why?
Lordship, COVID pandemic authorized close date. Lordship, order.
Which order?
Order, Lordship. Annexure 4, page 32 up to 36.
But was it for the entire year?
Lordship. Lordship.
You were given the contract for how long?
One year.
1 year.
month.
And it was closed for what?
Close from effect from 31st April 2021 to 30 August 48, next 9.
Hmm.
Effect. Lordship.
Okay. Then
View, I have an
why do you want 100% remission?
Yes, Lordship.
Why?
Lordship, NI, Lordship, page 16, annexure 1.
Hmm.
Page 22, Lordship. হাটখোৱা পৌৰসভাই দিব লগা কিস্তি ধন প্ৰাকৃতিক দুৰ্যোগৰ বাহিৰে অন্য কোনো কাৰণত ৰেহাই দিয়া নহব। COVID-19 Lordship, natural calamity.
Understood, but that was only for a period of 4 months. Why are you asking for the entire one? 100% remission.
Yes, sir. 100%.
Why?
Lordship, closure date order passed by municipal authority, Lordship.
Understood. It was from this particular period,
Yes, Lordship. Particular period.
from
19
page
weeks.
number 332 onwards.
19 weeks. Lordship.
Considering the present pandemic, it has been extended till weekly Mazar closure date for
Yes, sir.
closure of the weekly till 15th of July,
Yes, sir.
then 31st of July, 15th
Lordship.
of August, 31st of August. Then on 1st of September, it was reopened.
Lordship.
After 1st of September, if it was
Lordship,
reopened,
Per week, Lordship.
then why are you asking for 100% remission?
Lordship, close, Lordship, close.
Only
But-
for this period.
Oh, yes, Lordship. Only this period.
Then from
Lordship,
1st of
target close.
September, it was open.
Open, Lordship.
Then why are you asking for
Yes,
100%?
date, Lordship. But Lordship, close date. Close date. Lordship. Close day, Lordship, 90 weeks, Lordship. That means 90 days.
90 days.
Yes, Lordship.
Then
90 days into
how much you were supposed to pay total?
total Lordship price, bid amount, bid price, 20 lakhs, 786.
Hmm.
Divided by 52 weeks.
How much?
1 year, period.
Understood. How much?
Lordship, per week, 38,477 rupees.
Then they have given you how many weeks?
19 weeks. I am due 19 weeks, Lordship.
No, you are not 90
Authority-
weeks. They are not
authority
90.
issued 18 weeks, Lordship. I am calendar executive, Lordship. Annexure page,
They have given you for how long?
Lordship, annexure 5, Lordship. Calendar executive, Lordship. April, 31st April, 25, 1 day, Lordship. May, 2, 9, 16,
How much is per week?
per week, per day?
Per day, per week is how much?
38,477 rupees. April,
So they have given
25.
you almost 4.5 weeks.
Lordship,
They should have given you more.
19 weeks,
You should have got for 19 weeks.
19 weeks, Lordship. Calendar executive, Lordship.
And as such, which has not been granted.
Not done. And 100% I remain.
Issue notice making it returnable by 21st of December 2023. Mr. S.S. Roy appears on behalf of the respondent numbers 1 and
Lordship,
2.
Lordship, 3 and 4. I am appearing for 3 and 4.
I am
here.
for one.
You are appearing for 3 and 4.
Lordship.
Oh, fantastic. Now tell me why you have done that.
Lordship, I have to take the instruction. Lordship, just now I have to take.
No, it's on the face of it, it appears that it is 19 weeks.
Lordship.
Yes,
Why you have not given him?
Lordship, let me have the instruction next week, Lord.
Okay.
Calendar activate.
Next
Right.
week.
Issue notice making it returnable on 6th of December 2023. Mr. S.R. Borua appears on behalf of the respondent number 1 and 2 and accepts notice. Mr. S.S. Roy appears on behalf of the respondent number 3 and 4 and accepts notice. Extra copy of the writ petition be served upon the said councils during the course of the day. The case of the petitioner herein is that the petitioner was settled with the Deoboria Bazaar, that is the Sunday hut, for the period from 1st of April 2021 to 31st of March 2022 for an amount of rupees 20,786. In that regard, an agreement was duly executed. It is the case of the petitioner that for the period from 21st of April 2021 to 30th of August 2021, the said Sunday market was closed on account of the COVID pandemic, which is evidenced by Annexure 4 of the writ petition. Be that as it may, when the petitioner had sought for remission of the amount on account of the closure of the market, which is for the period from 21st of April 2021 to 30th of April 2021, which corresponds to almost 19 weeks. The petitioner have only been granted an amount of rupees 1,73,146, which effectively corresponds to 4.5 weeks, taking into account 38,000. How much?
700,
477.
38,407.
77 rupees.
Huh?
77 rupees.
407.
How is that? 77 rupees. 477.
77.
Yes.
477 rupees per week. And the petitioner further has been directed to deposit an amount of rupees 10,19,627. Mr. S.S. Roy, the learned counsel, appearing on behalf of the respondent number 3 and 4, submits that he will obtain necessary instructions as to the actual amount of remission to which the petitioner was entitled to, taking into account that in the impugned order dated 13/3/2023, it has been admitted that the COVID pandemic lockdown was for a period of 18 weeks with effect from 21st of April 2021 to 30th of August 2021. In that view of the matter, the learned counsel, appearing on behalf of the respondent number 3 and 4, shall apprise this court on the next date as to whether the amount of 1,73,000 146 would commensurate for the period, for a period of 18 weeks. Taking into account that the lease amount was taking into account that the bid amount was rupees 20 lakhs 00786 for the period from 1st of April to 31st of March, 1st of April 2021 to 31st of March 2022. Is it?
Yes.
Lordship, my name may be shown in the corpus.
Mr. S.S. Roy, the registry should indicate the name of Mr. S.S. Roy to stand as a counsel appearing on behalf of the respondent number 3.
For admission item number 5 and 6.
Oh, this one? Yes. Yes, why it has not yet been completed?
Lordship, charge sheet was submitted on Lordship.
Does it filed?
Yes, 31/10/2023.
See. The learned counsel, pursuant to the order dated 17/11/2023, passed in the instant writ proceedings, Mr. S.S. Roy, appearing on behalf of the respondent authorities, submitted that the charge sheet in respect of Sonai PS case number 49/2013 was submitted. Charge sheet in respect of Puenzo was submitted by charge sheet number 139/2020/23 dated 31/10/2023 against the private respondents. Against the private respondents. In that regard, he has duly submitted an instruction as regards the detailed investigation and the manner in which it was carried out. As stated, as informed by the communication dated 20/11/2023 issued by the Superintendent of Police, Kachar Silchar. taking into account the said communication is kept on record and marked with the letter X. Taking into account that the charge sheet has been duly submitted on 31/10/2023. Nothing further remains to be adjudicated upon in the instant writ petition, for which the instant writ petition stands closed. Who is appearing for the petitioners in this criminal petition? You are there?
Yes.
What remains? After the charge sheet has been submitted?
Yes.
You have to take action against the withdraw. The learned counsel appearing on behalf of the petitioners against criminal petition 871/2013. In the instant petition submits that in view of the fact that the charge sheet has already been submitted, being charge sheet number 139/2000/23 on 31/10/2023, the petitioner would not like to press the instant petition, but seeks the liberty to avail the remedies available against the said charge sheet. Taking into account the above, the instant revision petition filed for quashing of the FIR in Sonai PS case number 43/2013. 49/2013 stands closed upon withdrawal. Full stop. The withdrawal of the instant criminal petition shall not prejudice the petitioners herein to avail such remedies under law against the charge sheet, against the above charge sheet so filed against them. Yes, Mr. Dutta, you were not present on that day.
My lord, it is because of overlook, my lord.
Overload of work.
But this petition was engaged by another advocate, but he has not informed me.
Item 7 and 8.
Sorry for that, my.
These matters only you need to get that instruction and get the things done. Unnecessarily, this was pending from 2013. Immediately it has been done. Yes, what is this? Inform
is
From my instruction, Lordship, it was I has already received compensation of Jirat amounting to rupees 52,95,000.
And what is the other matter for? Anyway, we'll look into that.
8.
The instant petition has been filed by the petitioner. It is 2428. Seeking compensation for the land in possession of the petitioner, which have been acquired by the government falling under DAG number 23, 25, 29 of village Bornihat under Sonai Revenue Circle, Mozab, Sonapur, PS Sonapur in the district of Kamrup Metro. The legal counsel, Mr. S.S. Roy, appearing on behalf of the respondent, submit that as the petitioner's occupation was over the government land, the petitioner is not entitled to any compensation as regards the land. However, as regards the jirat, as regards the movals and removals standing thereupon, the petitioner have already been paid the compensation of an amount of rupees 52,95,035.16 over dark number 25 of village Borni, Moza, Hunapur, as per the order dated 28/11/2014, passed in WPC number 6080/2014. In that regard, the details, the award statement, insofar as the petitioner is concerned, and as to how the compensation was duly paid, has been enclosed. And as to how the compensation has been worked out, has been enclosed. The said instructions is kept on record and marked with the letter X. Taking into account the above, as the petitioner has received the compensation in respect to the jirat and have been denied the compensation on account of the fact that the compensation in respect to the land on the ground that the land belongs to the government, it is the opinion of this court that there is nothing further to adjudicate in the matter, for which the instant writ petition stands closed as infructuous.
My senior is flagging another.
Huh?
Senior is flagging another.
What?
My senior is flagging another, but matter maybe faster for the time.
Suppose then now you are saying all this. You have already got the money pursuant to another writ petition file.
Landless Angus Township is flagging another.
I can't help you. It is further made clear that if the petitioner is aggrieved as regards the award, as regards the compensation so awarded, liberty is given to the petitioner to approach the appropriate authorities seeking enhancement of the compensation as per law, if so permissible under law. And what is this other one?
Other one also for the compensation, but we have not got any instruction regarding this petition.
Huh?
This is also for compensation lordship. There are 11 petitioner, but
You have no instruction.
no instruction.
Get the instructions in the other one.
Lord.
Mr. S.S. Roy, appearing on behalf of the respondents, shall obtain instructions as regards the question of, as regards the acquisition as well as the compensation status in respect of the land wherein the petitioner claims whereupon the petitioner claims compensation in the instant writ petition. Is the matter again on?
Earlier petition was also for the same dags, Lord.
No, there are many other dags here.
In the same in that petition.
Is the
also
matter
there-
again on 11th of December?
Lord.
Get your instructions for that.
Right.
Here there are 4-5 dags.
Lord.
Yes, Mr. Counsel.
My lord, I'm appearing on behalf of my senior, Mr. K. Bhuya. May I submit, my lord?
Yes, please do.
My lord, with your permission, I'd like to give a brief about the matter.
Hmm.
My lord, what happened is that the petitioners used to reside near the Becky River in Borpeta district. And what happened is that in 2002, during the floods, the soil was eroded and the people became homeless. So what happened is that the respondent number 3 made a list of the beneficiaries and wanted to and allotted a plot of land under tag number 282 and 6.
Allotted?
Uh,
Recommended.
recommended.
Okay.
Pardon
But
my-
you could not get it.
However, my lord, what happened is that in the year 2008, on the same plot of land, another approval was made wherein the same plot of land was referred to the respondent number 5 and 6. My lord, now what happened is
He
that
has also not been granted allotment.
Only just recommended, my.
Recommendation. But you see, it is a VGR land.
Yes, my.
So as this is a VGR land, you
Yes,
cannot
my
give
lord.
any
And
allotment to any of it
last occasion.
as per the Jakpal Singh judgment. So you have to, both of you, I think, required to file appropriate application. This court can't give any direction to allotment to you both of you. Okay.
my lord, in notification, there was a scheme called Chief Minister's Special Scheme for Rehabilitation of Erosion Affected Families. My lord,
Understood, Mr. Counsel. Kindly appreciate one thing. There is a judgment of the Supreme Court wherein it says, that is a judgment in Jakpal Singh, wherein it says that lands which are reserved for community, lands which are village reserve lands, grazing grounds, these cannot be allotted. And any allotment which was made also in that case, which was in the state of Haryana, was held to be bad and they were asked to be thrown out. So there cannot be anything. Now you are referring to that Chief Minister scheme,
yes, my lord.
but that Chief Minister scheme has to be read with the government policy. Now if you see government policy 14.2, what is that? I can go to government policy. In the government policy also it is mentioned that there cannot be allotment on BDF. So if there is any allotment to be carried out, has to be in waste. I hope you know what is wasteland.
Yes, my-
Where is it? What is it?
my lord, where the land which is not fertile and it cannot be used for grazing or farming, etc.
No, no, no.
Like those, my lord.
It is the the dictionary definition. Wastelands will be as per section 2C of the settlement. Now you see, as per the government policy, where is that there cannot be any settlement.
My lord, the petitioners have waited for a very long time, my lord.
So
It's
what?
been
Can't
almost
help you.
21 years, my lord. And
There can be no settlement. Yeah, Deputy Commissioner shall make necessary endeavor to preserve the existing VGN area for use of members of public for the purpose for which those are constituted and encroached on by area, if any, will be removed. Henceforth, land of VGR will not be further decreased by way of de-reservation and allotment, etc., except for public purpose under special as defined in judicial pronouncement. This is the law. I can't help you.
my lord, the office had directed, the office had approved of,
What about that office? That office has no business.
it was only half a biga land per person, my lord. There were 78 petitioners, my lord. And
You want to pay the deficit court fee?
Pardon, my lord.
You want to pay the deficit court fee? And get a dismissal? Both? You do one thing, both of you, you file applications
Yes, ma'am.
under Vasundhara. Is it available, Vasundhara?
Yes, ma'am. It's there.
Still there?
Yes.
Is it there? It's there.
But
So
this
let
court-
them apply. But they cannot be granted allotment in respect of this land, which is reserved, VGR land. Okay, so they will apply as per the government policy. Let them apply. But you cannot be allotted these lands under DAG number 282 and 632. And who is this? Hamid Ali is yours?
Yes, my lord.
Then Batsa Alam,
Yes, my lord.
all three.
Yes, yes.
And you are appearing for
Record number 5.
in
In all the cases I have been made.
understood, but he's the respondent number 5 everywhere.
Yes, ma'am.
This is a school.
School, ma'am.
Okay.
My lord, this petition arose out of necessity, my lord. The petitioners are homeless, my lord. And
So homeless, no homeless, but then also there can be no allotment, na? Can't
my
help
lord,
you.
it has been 21 years, and my lord,
No, they will give. You are erosion affected.
Yes, my lord.
They will consider as per this. You file your application, but you file your application within 30 days, both of you. And they shall not evict them till the disposal of the application, provided they file within 30 days. Okay.
I'll come in.
My lord,
The 3 petitions are taken up for together, taking into account the common issues involved. The petitioners herein, in the 3 petition, claim to be erosion affected persons. And they have been in occupation of land, government land, covered by dark number. कौन कुछ बोले?
282 and 630.
Give a piece of paper. Where is it? To the dark number 282 and 632 of Jonia village under Jonia Moza within Bagbor Revenue Circle. The petitioners herein are aggrieved by the action of the Subdivisional Land Advisory Committee in recommending allotment of land in respect of dark number 282 and 632 in favor of the respondent number 5.
Only 630, not 282. Respondent 5 has been.
Being agreed by the allotment of land in dark number 632 in the aforesaid dark number 632 situated at village Jonia under Jonia Moza within the Bagbor Revenue Circle. It is an admitted fact that neither the petitioners have been granted any settlement, nor the private respondent number 5. It is only the recommendation was made by the Subdivisional Land Advisory Committee. On 15/11/2023, when the matter was placed before this court took into note the instructions dated 18/5/2022 issued by the Deputy Commissioner Borpeta, wherein it was mentioned that dark number 282 and 632 of Jonia Revenue Village under Jonia Moja is a reserved land, bracket VGR. It was also mentioned that the SDLAC held on 6/11/2002 had recommended land measuring 39 bighas of land measuring 39 bighas covered by dark number 282 and 632 of Jonia Moja of Bagbor Revenue Circle to the erosion affected people of Beki River. Further to that, it was also mentioned that as per the report of the Circle Officer, Bagbor Revenue Circle, dark number 232 is a periodic patta land, but in dark number 282 of Jonia Village, 16 bighas of land has been recommended for allotment to the erosion affected family of the river Beki. This court have also taken note of the said instructions. sought for further instructions from the respondent authorities to the effect as to how the reserve land, that is village grazing reserve, can be allotted or settled unless the said land has not been de-reserved. This specific instruction was sought for in view of the judgment of the Supreme Court in the case of Jakpal Singh versus, anybody knows anything?
Jakpal Singh and others versus State of Punjab and others.
Reported in
2011, 11 SCC 396.
wherein it has been categorically observed by the Supreme Court that reserved community lands cannot be settled. Today, when the matter was taken up, Ms. M. Borman, appearing on behalf of the District Commissioner Borpeta, had submitted that
No de-reservation process.
on 6/11/2002, recommendation was made for allotment of land in Dag number 282 and 632 of Donia village of Donia Moja under Bagbor Revenue Circle, which is a Vizier land. However, no de-reservation process was seen to have been initiated. This court at this stage also finds it relevant to take note of the land policy of the government of Assam, dated Assam, which specifically deals with, wherein clause 6 specifically deals with village grazing reserve and professional grazing reserve and other reserve land. Clause 6 of the said land policy is quoted herein, reproduced herein under. From the perusal of the above, clause 6 as well as its subclauses, it reveals that land under VGRs and PGRs would not further be decreased by way of de-reservation and allotment, etc., for public purpose. An allotment, etc., except for public purpose under special circumstances as defined by judicial pronouncement shall not be made. In view of the specific land policy of the government of Assam, being land policy, 2019, as well as the judgment of the Supreme Court in the case of Jakpal Singh, the question of allotment of the land which have been specifically reserved as village grazing reserve, in the opinion of this court, cannot be made in favor of either the petitioners or even the private respondent. Under such circumstances, this court is of the opinion that no writ can be issued directing the respondents to consider the settlement in favor of the petitioners in respect of Dag number 282 and 632. This court further sets aside and quashes the recommendations so made in favor of the respondent number 5 for settlement of land in Dag number 632. Be that as it may, this court, however, taking into account that the petitioners herein are erosion-affected families, and also that the respondent number 5 is running a school
Since 2000.
since 2000, grants liberty to both the petitioners as well as the respondent number 5 within a period of 30 days from today to file appropriate applications seeking settlement. It is made clear that this court further directs the concerned the revenue authorities as well as the district commissioner, Borpeta,
Yes, sir.
to consider the said representations, said applications seeking settlement as per the land policy of 2019. And also that the petitioners herein are erosion affected families. It is made clear that if the petitioners herein filed the application seeking allotment in respect to other wastelands of the state of Assam, of the wasteland wasteland of the government of Assam, the respondent authorities within the time permitted herein above, the respondent authorities shall not evict till the disposal of such settlement applications. With above the pinch,
No,
three
the petitioner school, they also cannot be.
Huh?
The school of the petitioner.
as well as the respondent number 5.
Much obliged.
All right.
Liberty দুইটাকে দিয়া the তাতে এটা ওপৰত এটা লিখিব এটা ইনষ্ট্ৰাকচন এওঁ যে ক'লে নহয় তেখেত এইটো ন ইনষ্ট্ৰাকচন এটা কথা ক'লো না আজি যে ইনষ্ট্ৰাকচন দিছে that 632 এইটো ডি ৰিজাৰ্ভ কৰা নাই বুলি কৈছে the said instruction is kept on record and marked with the letter Y. Instruction concise. De-reserve কথা কৈছো না এতিয়া কৈছো however no de-reservation process have been initiated. The said instruction is kept on record and marked.
Okay.
Yes, Dr. Todi,
My lord,
this is your matter, na? That is the insurance one.
my lord,
That has been pending out there. I asked them to get the instruction. Oh yes, what is your instruction?
not received, lordship.
They are not giving.
Not.
So we direct them to make the payment within a period. I
Got
think that is the only way out because the state or central
Well,
government is not.
Not received, lordship. We have sent reminder also, lordship. We have not received. My lord, in fact, my lord, if you lordship may kindly peruse the, my lord, all the 9 cases are there for 9 years, my lord. My lord,
That is admitted. There is no dispute in
No,
that.
I'm
Their
not-
cases are
that-
pending.
I'm not saying that they are disputing, my lord. Only, my lord, what happened? If you lordship kindly have a look, my lord.
Yes.
This is 9 years, my lord. In fact, like if you lordship kindly have a look, my lord, on the right hand side, claim forwarded by the district, my lord, industry center, my lord. My lord, way back in 7, 8, 9, 10, you go down below, my lord, and my lord, now 2023, my lord, they are sitting over the issue for so long. And that apart, my lord, so far the dispute is not there, my lord, except that if you lordship can kindly see, my lord, I will just briefly, my lord, I will just, if you lordship allow me, lordship may kindly come to page 36, my lord. My lord, in fact, my lord, this is the first thing, the eligibility, my lord, because one is to get registered with the district interest center for the purpose of claim, my lord. Then, my lord, lordship may kindly come to my lord, page 39, annexure 5. This is, my lord, provided in 2013, my lord, by General Manager District Industries Commerce Center, Tinsukia. Then, my lord, down below the last paragraph, my lord, lordship may kindly say the applications are duly inquired by so and so functional manager of this TICC with all relevant documents, which may kindly be placed at the next level, state level committee to be held. My lord, since they have been sitting over there, and then, my lordship may kindly come to page 38, my lord, annexure 4. This was the amount, my lord, which has been paid, my lord. Lordship may kindly see down below the amount paid, my lord. 81,071 net premium, madam, including my service tax paid. That was the paid. So, as per the scheme, my lord, the petitioner is entitled to get the 100% reimbursable, my lord. They to be reimbursed 100%. But they are not disputing that. But only, my lord, difficulty now they have dealt with the case, my lord. And, my lord, because of the inaction on their part to disburse the, my lord, the subsidy amount within time, my lord. My lord, systematically, number of cases have been, my lord, decided by this Honorable High Court, my lord. And, my lord, 2 division bench judgments are also there, my lord. Except in 1 division bench judgment recently, my lord, in 2022, my lord, they have, my lord, Union has gone to Supreme Court, my lord, to challenge the interest part. My lord, High Court has granted interest, my lord, on the equitable ground following Supreme Court judgment Ghaziabad case, my lord, development case. That, my lord, in fact, suppose in absence of any provision contained in the scheme, my lord, interest on equitable ground can be paid when, my lord, for no good reason, my lord, they are speaking about the matter, my lord, on that case. So, my lord, in fact, my lord, so far the interest part is concerned, earlier also, my while 2011, my lord, that the case got finality because the Union of India did not move to Supreme Court. That department subsequently also, my lord, they went to Supreme Court. That case was dismissed. Now again they have gone in another case on the same ground, my lord, which is pending, my lord. So, my lord, if my lord, or respectful submission is that, my lord, if may kindly, my lord, direct that, my lord, the amount should be paid, insurance amount may be paid, and so far interest part is concerned, my lord, should be kept pending, but open and leave it with the limit. After disposal of the Supreme Court case, my lord, we can approach the forum again. But this is, my lord, respectful submission, my lord. And they have not filed affidavit, only one affidavit filed by NETP, my lord, They have only one affidavit filed way back, long back, my lord. They said that, my lord, once the amount is disbursed to us, then we will make payment. So they said that we are ready to make payment, but this direction should come.
So what do you propose? As to, you see, now the thing is, this is under the 2097. This is under the 97 policy. So 97 policy, there was a particular modus in which it was to be done. Now then came the 2007. Now once the 2007 had come in, there is a different modus by which it has to be paid in a particular different manner. Earlier, it was to be reimbursed in a particular manner, and now it is to be, some certificate is to be given.
Yes, now it will be approved by the SLC, then net fee will be the disbursing agency.
Earlier it was
Earlier,
direct.
National Insurance Company, directly, National Insurance Company was there. So National Insurance Company will be given the receipt or whatever insurance premium payment, then they will reimburse it. That was the easy process was there earlier. Now later on, like there was a lot of.
Now the SLC will see.
Yes, SLC will verify it, then they will approve it, then only they will send it to NetFeed and NetFeed will disperse.
So what is the modus now to be followed in view of this? Would be the new, will be the SLC.
Well, SLC, in fact, my lord, SLC, my lord, Commissioner of Industries, my lord, he is also a member, SLC. Now, what the thing is that, my lord, 97, my lord, is initial for 10 years. Then 2010 came, 2007 came, scheme came, that also for 10 years. So, my lord, the procedure is same. But what my landed friend is submitting, my lord, outside the, my lord, his casual statement is making, but not affidavit, but supported by affidavit.
Why he is saying it's
My lord,
a
only
casual
thing is, my
statement?
lord, I should be supported by, my lord, unless factual foundation is there, my lord. Perhaps,
Why he is saying it's a casual statement? He said, I'm an officer of the court, I'm stating before the court, but don't make a statement that I make a casual statement. I'm making a statement on the basis of the instructions.
No, let us, Mr. Kothi, let us not go into those things. But why I'm
No, wait,
asking you
being a
a
senior
specific reason is this.
I will read out the
Earlier, there was a modus by which it was to be paid in a particular manner. Now there is a different modus, and that is the reason why the NETP has been, or the SLC has been requesting the government of Assam to give us, or government, the state of the Union of India to provide in the instructions in which it is to be carried out. Now, this court will pass a direction to allow, but what is the modus to be followed? That is what I am
My
asking.
lord, may I second? In fact, for about 2 years, Lordship may continue only for 2 years, that is, my lord, under the 97 scheme, my lord. And for 7 period, my lord, for 7 years, it is a 2007 scheme. Now, my lord, what happened? Ultimately, my lord, the thing is that, my lord, so also I have got also the scheme with me, my lord. The scheme says that, my lord, it should be, my lord, when it was recommended by the district industry center, my lord, with request, my lord, here it is requested that it should be placed before the SLC. Now the thing is that ultimately SLC, the state level committee, my lord, who is to recommend. So in all the cases, my lord, that means they are to look into the matter and, my lord, scrutinize the matter and to send to the NETP for discussion. Now, my lord, question is this. But in other cases, my lord, normally what happens, my lord, some scrutiny takes place, but I don't say that they should not scrutinize it. But, my lord, here is only the policy is concerned. So the premium paid, my lord, against the insurance policy taken, my lord, which is Lordship will find it annexure 4. But my lord, there is nothing to verify because national insurance company, my lord, isliye my lord, nationalized my lord insurance company. So my lord, in other cases, what happens? Support interest subsidy, transport subsidy, then my lord, some calculations are required, my lord. Normally, the number under the same schemes, my lord, they depend some my lord, transport subsidy, interest subsidy, lordship is ever all those things. So my lord, so far this particular case is concerned, my lord, the way my lord, the matter has been dealt with, my lord, over the years. But keeping in view of that and my lord, consistently, my lord, whatever the judgment passed by this honorable High Court, my lord, perhaps, my lord, the direction will be given that yes, the within a time frame, my lord, is that which is per.
That I will do. My question is very simple. Should this court direct now that the respondent authority shall follow the procedure which is being given for the NIP NIETP 2007 for the purpose of disbursement of the insurance subsidy to the petitioner?
Yes,
that's it.
Yes, sir.
I'm asking you a simple question. That is it. Because this court has to, before writing the judgment, I have to first formulate in what manner I'm going to pass the order. So this court, I think, is the best of the, it will be the best. It will be in interest of both the parties that this court passes a direction to the respondent authority to determine the and look into the claims on the basis of the NEIPP module, and thereupon disburse the amount within a time frame of 4 months.
No, Lordship, like one issue is there. What my learned friend is submitting is that under 1997, they are registered under 1997 scheme. And like 1997 scheme provides that after the commercial date of operation, they will be eligible for 10 years. So all their claims are basically under 1997 scheme.
Understood.
Correct.
You see, there is no problem that they are not on, but who is going to? Why have you not given? The only thing which I could see from the letter from your Commission of Industries to the court to the Department of Industrial and Promotion is looking at that this was the state of affairs. Under what method should we do it? Kindly provide us the method.
Only the power empowerment
method.
Yeah,
not the
they asking for the empowerment also because Lordship, this SLC is constituted under 2007 NEIPP. So what they are basically seeking that like
there was no SLC earlier.
No, there was no SLC earlier. That is what I'm saying, Lordship. Earlier SLC was not there. National Insurance Company was the nodal agency, and they used to disperse it under 1997 scheme. So 2007 scheme, Lordship, that SLC thing has come brought in. So insurance scheme, this policy under insurance also claims also, those has to be scrutinized by the SLC. Now SLC is in a difficulty. SLC is saying that we have not been given any power, specific power under 2007 to look into the matters under 1997 also. Because under 1997, the issues were different because the nodal agency was different. Now we'll have to refer it to net fee. So we'll have to approve it. We are empowered to approve only under 2007 scheme. So his company is basically registered under.
Show me the power in which you have been approved, given the approval.
Which approval, Lordship?
For the SLC 2-3.
Yes, but that under 2007.
Because here the problem therefore arises is how can this court empower an authority?
Correct. That is what I'm saying, Lordship. I mean, if the central government clarifies that, like they can come up with some kind of legislation, some kind of.
To be how SLC has been empowered.
Yes,
and what was the state of affairs prior to that?
Yes, Lordship. Yeah.
Who is appearing for net fee?
Okay, we are the provided fund is being allocated to us by respondent number 100.
Show me that policy. Let us see the policy of
page 21, Lordship.
Designated agency for disbursement of subsidy. Now this is by on 27th of July 2007. It is a comprehensive insurance scheme.
Correct.
But I mean, Dr. Todi, you are not applying under Annexure 2. Your claim is not under Annexure 2. Page 26.
My lord,
Is your claim under Annexure 2?
yes, my lord.
No.
So they registered under 1997.
Your claim is under not this scheme, the earlier one.
My lord, so far as my lord,
Here, if it is there, there is no problem.
my lord, so far 2.7 is concerned, my lord, even there for time is no problem. And my lord, I think, my lord, that can be, my direction can be given. But so far as the, my lord, earlier 1997 scheme is concerned, my lord, what I beg to submit, my lord. In any case, my lord, what my learned friend is submitting, that insurance company is the notified or the officer, insurance company cannot give of their own. That has to be rooted to the, my lord, state agency. Insurance company, my lord, so far no part, my lord, the insurance company has not been so far. Let him show the power, my lord, to what the insurance directly has been given the power to disburse the amount. In any case, my lord, this will be after scrutinized, my lord, has to go to the net fee, my lord, in both the cases. Now, my lord, what happened? Under the policy, what lordship, my lord, may update under the policy, my lord, let the matter be settled. Whatever may the manner. But my lord, what they had been doing, my lord, they had my lord, the bounded duty to disburse the amount, my lord. The respondents, my lord, collectively they have the bounded duty, my lord. They are the monitoring authority, my lord. So they cannot say, they cannot just push up the, my lord, the responsibility to the insurance company. Insurance company, even the wish not, they cannot give of their own. It is the, my lord, they have to call the record, they have to, my lord, the thing, then they disburse the amount to the direction to be given to net fee, my lord, for disburse.
Lordship can have a look on this SLP minute.
Yes.
So, my lord, what I beg to submit, my lord. So far, my lord, so far 97 is scheme is concerned, my lord. But insurance company, my lord, if my lord, has got the, my lord, scheme that insurance company directly can make payment, even then, my lord, they are the supervising authority, my lord. Direction has to go from my lord to the respondent. Make this person.
Where is the Central Comprehensive Insurance Scheme 1997?
That is there in the petition itself.
No, it is there.
Yes.
But it is there, my lord. I can.
It is there in page 26, Lordship.
Where?
Read petition.
No, it is
That's
not there. They are bringing in the 97, 2007 only.
2007.
No, where is the 97?
97 they have an next.
My lord, 97, my lord, we have, my lord, taken a ground to pay plead, my lord,
Huh?
My lord, at the relevant point of time, lordship, my lord, we have already stated, my lord, para 7 of the petition, my lord, page 7, petitioner gave plead to produce a copy of the Central Company Insurance from 1987 at the time of hearing of the petition. At the time, it was not available with us, my lord. My lord, many things are not available.
No, you come under which scheme? Because you set up your industry in 1997.
But we come under the, my lord,
Pursuant to 1997.
so far, my lord, two periods are concerned. WPC, my lord, lordship may kindly have a look at the list, my lord. 1304 2017 WPC and 1307 2017. That means, my lord, period 14/7/2006 to 13/7/2007 and my lord 14/7/2005 to 2006. These two periods are under 97 scheme. Only these two, but rest 7 are under.
No. How is your eligibility? Eligibility will be you setting up your industry within the framework, within the time when the industrial policy has come in.
Sir, Lordship may kindly see, Lordship may kindly peruse one thing, their registration. The registration is at page
Where is
37. Page 37 of the petition.
Page
37.
36.
2007 scheme, my lord. It's
Page 37, Lordship.
That is but 13, 14, my lord.
That under the state subject scheme.
13, 14, my lord. Period is 13, 14. What my learned friend is pointing out, my lord, that is for the period 13, 14.
They are registered.
No, you are referring to the, I'm looking into Ishwar Food Products 1291.
My lord, then I pay my lord, that lordship may kindly take up the matter 1307 to
No,
1304.
Lordship may kindly take up 1284. That is on the top. 1284 of
That is
2017.
scheme.
1284.
1284 is under 2007 scheme, my lord.
No, it is not.
Let us see, let us see. Where is your registration?
That is their document, Lordship, I am referring to.
Where is
Page
the
37.
page?
37, Lord.
That is what you are registered under,
Registration
in
under
writing
Central
reference to the subject. I'd like to
1997.
inform you so and so have been registered under the scheme by so and so dated 10/3/2005.
And Lordship, one more thing, Lordship may kindly see the bottom. You are requested to submit your claim in prescribed format within 13 days from the date of issue of the matter, National Insurance Company.
National Nodal Insurance.
Nodal Insurance Company, sorry.
My lord, may I submit,
Nodal Insurance Company is National Insurance Company.
my lordship is taken up the case, my lord. Which case my lordship is taken up? My lord, let me
1284.
let me clear, my lord.
Yes.
1284, my lord, this period relates to
84.
my lord, this period relates to 14/7/2013 to 13/7/2014, my lord.
No, but you registered under what scheme? You registered under the 97 scheme, na? Under the 97 policy.
I am coming to that. I am coming to that. In fact, my lord, what happens, my lord, what I find here, my lord.
Yeah, kindly come to paragraph 5 of your petition.
Yes, my lord. That the petitioner company back to state that the petitioner is also registered under the Central Company Insurance Scheme 1997 and has been allotted the registration number.
So you were under 97.
But in fact, my lord, what I am going to say, my lord, my lord, there, my lord, some mistakes were kept in.
Why?
By my lord, writing, my lord. In fact, my lord, the 97 scheme continued for 10 years, my lord. 97 continued, my 2007, up to 2007 continued. So meaning thereby,
No.
this is for the period.
No, Mr. Dr. Todi, kindly appreciate. 97 scheme was for a period, 97 scheme was for not only for a period of 10 years, but another thing is the 97 industrial policy was for a period of 10 years. Now, just for example, in the fag end of 97 policy, somebody gets registered or sets up his industry. Then he will be entitled for 10 years as per the 97 policy. So this is here where you have set up your industry sometime in 2005, before the coming into effect of the 2007 scheme. So under such circumstances, you will be entitled as per that. And once you are entitled out there, this is the submission of Mr. Kolita to the effect that earlier it was the Nodal Insurance Agency who was paying. But now, as per the 2007 scheme, the comprehensive policy of 2007, it is done through the SLC. Now, the problem which is happening with the SLC out here is that the SLC has not been categorically empowered by the central government in respect to those schemes. So that is why they have been writing many letters. Now, in response to that, the central government is keeping quiet.
Well, after 10 years, but I think later after 10 years, my lord.
Understood, but central government is keeping quiet, and that is why before this court.
My lord.
And this matter has been pending for the last 6 years.
My lord, not for the reason, my lord, that my lord, they have not pointed out, my lord, in that case, my lord, Markham Textiles case, Supreme Court, which will be constitutionally followed by the, my lord, all the courts, my lord. Yet it, my lord, said this benefit and public purpose has to be, purpose, the schemes are floated. But it should not be dealt with the, my lord, pedantic manner.
Dr. Todi, kindly not digress from that point. My point is very simple. Here is a case that SLC have not been empowered as per the 97 scheme.
True, my lord.
Kindly appreciate. Once the 2007 has come, in that scheme, SLC have been empowered. Now the question is, can this court empower the SLC? In absence of the government empowering, that is the specific question.
Well, may I submit, my lord? In fact, my lord, what my learned friend is submitting, my lord, even I have not gone through that, my lord. But let him produce, my lord, that at that time SLC was not there, and this is the procedure.
Who is the petitioner?
My lord,
Who is the petitioner?
No, but
It
respondent.
is for you to produce.
I'm coming to that.
Then otherwise, the documents are makes it very clear that it is not. In fact, your document categorically shows that it is the nodal insurance agency, and your application was to be filed, and that is a document which you have filed out here.
May I submit, my lord?
So
Yes, my lord.
why haven't you brought on record the insurance policy under which you were registered before this court?
But even then, my lord, even then, suppose, my lord, let us let it, my lord, even I presume, my lord, that 90 TZT, my lord, is to be dealt with national police. My lord, I understand that. But even then, my lord, under that policy, whatever the system was there, my lord, it should have been cleared. That's what my submission is that.
Understood. Dr. Todi, kindly appreciate this court wants to help you, but in helping you, how it is to be helped is the question.
Yes, ma'am.
I don't want to pass an order by which tomorrow you are put into more difficult troubles. The union immediately will jump up and file an appeal. What is to be done if the SLC have not been empowered? How would this court direct the authorities to consider your claims if that SLC have not been empowered? Can this court step upon the power of the union to appoint, direct the SLC for doing it? That is the specific question.
My lord.
You address this court on that. We'll take it up at 2. Yes.
Correct to detect. But that thing is there, my lord, that what so far is for your 2 years, or that is out of 9 petitions, 2 petitions, my lord. There, my lord, the central government will look into the matter, why it was not reimbursed. My lord, central government will take a view to it. And my lord, ultimately, my lord, so far the petition is concerned, my lord, under this scheme, my lord, he is to be paid. He is to be reimbursed. Only simple thing. If there are some defect, my lord, or to be pointed out by central government with regard to petition. To take to 99 scheme.
But Dr. Todi, I was thinking the best way was
My lord.
to direct the union to set up the modalities within the time frame, and thereupon, on the basis, the moment it is settled, is set up within a further time frame to clear your to disburse them. I think that is the
Yes.
best way.
My lord.
That is the best way.
That would not be this court encroaching upon the power upon them
Correct.
and appointing an authority.
Yeah, absolutely.
Let them appoint, and if they don't appoint, you have a right of contempt.
Yes, sir.
I think that is the best way.
That is the best. That is the best.
My lord, only my lord, may I pray, my lord.
Yes.
But there, my lord, is so far the my lord, the entitlement is there under the scheme. Under the scheme, already entitlement here, under the scheme, my lord, to be paid. But it to be made clear, because what happened, my lord, but while they're recommending the amount for the service charge, etc., they deducted, my lord. They deducted service charge, whatever the under the insurance claim. So meaning thereby the amount substantially reduced, my lord. So
No,
those things are-
whatever is there in the scheme, they are and they shall give it to you.
my lord.
If you agree by the amount, you can very well, you are always at liberty. Why should this court decide on that? You are entitled as per the scheme.
Yes, ma'am.
That's
No
all.
doubt about it, ma'am.
This court will only make it clear that you will be entitled as per the scheme. And if you are entitled to whatever amount that is, I think these niceties be left with the authorities.
Absolutely, Lord. If
My
they
lord,
agree, then we can
my lord,
always.
I think we are obliged, my lord. That is, that's
I
my
think
lord.
that is the best way out.
And my lord, so far the interest part is concerned, my lord, that my lord, subject to outcome, my lord, that might be observed, because other court also observed in the same manner, my lord, that I can produce before you, lord, my lord, that judgment recently also passed, that
So
subject
in
to
that,
outcome, liberty can be
in
granted.
that SLP lordship status quo is suppose, I mean, status quo is maintained.
Which one?
So what has happened, lordship, that as far as the subsidies are concerned, if there is a delayed payment, whether the interest will be liable or not. So that was the issue that has gone to the Supreme Court. SLP has been filed by the state, and Supreme Court has stated that status quo to be maintained. So matter
So
will be
under such
decided.
circumstances,
Lords.
depending upon the judgment of the Supreme Court
Supreme
in
Court.
that judgment,
Correct.
in that case,
If they,
the
if,
petitioner shall have a right
correct, Lords.
over that
Correct.
amount to claim interest,
Absolutely.
depending upon the outcome of the.
Absolutely.
I think that is the best way.
I don't have any problem.
Look at period set, I have already forwarded, my lord.
These are the 9 writ petitions.
Yes, ma'am.
Lahore. The right, the instant batch of 9 writ petitions are taken up for disposal by the taken up for disposal by this common judgment and order, taking into account the similarity of the facts and the common issues involved. It's the same petition. The petitioner herein, who is the same, the petitioner herein is a company incorporated under the provisions of the Companies Act 1956. The petitioner is in the business of manufacturing of grain meal products, starches, starch products, and prepared animal feeds. In the year 1997, the Department of Industrial Policy and Promotion, Government of India, had launched a scheme and had launched an industrial policy dated 24th of December 1997, known as the Northeast Industrial Policy 1997, for short NEIP 1997. The said scheme, in the said policy, covered the states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, and Tripura, as well as Sikkim. Various incentives were provided to the industries which were set up pursuant to the said industrial policy, as well as also to the existing units which go in for substantial expansion, with effect from for a period of 10 years, with effect from the date of their commercial production. Amongst the various incentives, one of such incentive was the Central Comprehensive Insurance Scheme 1997, which was notified by the notification bearing number 17/1/98-DBA-1, dated 14/7/1999. As per the said scheme, the scheme, it was made applicable to new industrial units set up in the northeastern region after 24/12/1997. To come within the said industrial unit to avail the scheme, the industry has to be included in the fire policy bracket C as per the All India Fire Tariff. The manner in which the payment of the said the scheme would be worked out is stipulated in clause 6 of the said notification dated 14/7/1999, which mandated that the insured, that is the industrial unit, shall pay the initial premium, which shall be reimbursed by the nodal insurance company bracket National Insurance Corporation bracket close, out of the revolving fund maintained by that company. The funds for the said revolving fund shall be contributed by the Ministry of Industry, of Industrial Policy and Promotion. The petitioners herein, as could be seen from a perusal of the writ petition, registered under the Central Comprehensive Insurance Scheme 1997 and was allotted the registration number DIN and to CC/CIS/TSK-29 dated 10/3/2005 by the letter number TDICC bracket CCIS apostrophe 97 bracket close 33/2004-5/1606-07 dated 11/3/05, which was issued by the General Manager, District Industries and Commerce Center, Tinsukia. On the basis of being registered, the petitioner submitted its claims for the various periods, the details of which the said claims were duly forwarded by whom?
District Industry Center.
District Industry, by the General Manager.
General Manager.
General Manager, District Industries and Commerce Center. To whom?
Commission.
To the Commissioner
Commissioner
of
for Industry and
Industries.
Yes, Industry and Commerce Department.
Industries and Commerce Department of the state of Assam. The details of the claims of the petitioner with specific reference to the period and the amount so claimed, as well as the date on which the claims were forwarded, are enumerated herein below in the table hereinafter. খালি এটাই কাম কৰিব, এই ৰিপিটিশ্যন খিনি লিখিব নালাগে, ঠিক আছে? এইকেইটা লিখিব, সেই তলৰ পৰা লিখি যাব ওপৰলৈ, because 2005, 6, 6, 7, 7, 8, 8, 9, 10, এনেকে লিখিব ঠিক উল্টা হৈ The petitioner, though, submitted its claims, and the said claims were duly forwarded, but the payments were not made, were not disbursed. The entitlement of the petitioners were not disbursed, for which, against the respective periods, the instant 9 writ petitions have been filed, seeking for appropriate directions upon the respondent authorities for disbursing the amounts payable to the petitioner as per the Central Comprehensive Insurance Subsidy Scheme 1997, as well as also have sought for interest at the rate of 1.5% per month on the said claims. The record reveals that notices were issued by this court making it returnable by 6 weeks. None of the respondents except the respondent number 5, who is the net fee, which is the Northeast Development Finance Corporation Limited, have filed the affidavit in opposition. It reveals from the records that on 5/10/2023, when the matter was taken up, the council, appearing on behalf of the Industries Department of the Government of Assam, submitted that though the petitioner's claims were duly forwarded, though the petitioner's claim, along with various other claims of other industries, were forwarded pertaining to the Central Insurance Subsidy Scheme 1997 under NEIP 1997, but the said claims could not be recommended by the state level committee or recommended for disbursement in view of the fact that the National Insurance Corporation, which was the nodal agency as per the Central Comprehensive Insurance Scheme 1997, ceased to exist, coming into effect with the coming into effect of the Northeast Industrial and Investment Promotion Policy 2007, as well as the Central Comprehensive Insurance Scheme 2007, whereby the modality for the purpose of disbursement of the modalities for the purpose of operation, verification and disbursement of the insurance were changed, and thereby it was the state level committee so constituted who was empowered for the purpose of making necessary verification and thereupon recommendation for the purpose of disbursement of the insurance premiums. The Learned Counsel for the Industries Department submitted that taking into account the above, there has been various correspondences between the industries, between the Commissioner, Industries and Commerce, Assam, with the
DIP.
Department of Promotion of Industry and Internal Trade of the Union of India, so that appropriate instructions could be given for the purpose of verification and may thereupon making recommendation for disbursal of the amounts pertaining to the insurance claims under the Comprehensive Insurance Subsidy Scheme 1997. The Learned Counsel further stated that apart from the 9 claims of the petitioners, there are also another 102 claims which are also pending, which could not be pending in respect to the Comprehensive Insurance Subsidy Scheme 1997, which could not be disbursed on account of not finalizing the modalities by the Department of Promotion of Industry and Internal Trade, Government of India. The Learned Counsel had placed before the court a communication dated 10/8/2023 issued by the Commissioner of Industries and Commerce, Assam, wherein the details have been mentioned and also requesting that certain clarification be issued for the purpose of making necessary verification and recommending the insurance claims so that the said claims could be disbursed at the earliest. This court, by an order dated 5/10/2023, directed the council directed Mr. R.K. Dev Chaudhary, the learned DYSGI, to obtain instructions on the communication dated 10/8/2023 on the next date, so that the matters could be disposed of could be decided. This court further fixed the matter on 15/11/2023. On 15/11/2023, when the matter was listed, it was informed by the Learned Counsel appearing on behalf of the Government of India, of the Union of India, that as per the directions contained by this court in its order, the directions contained in the order dated 5/10/2023, due communication was made on 13/11/2023 to the Secretary to the Government of India, Ministry of Commerce and Industry, Center of Industrial Policy and Promotion, but there was no instruction received. This court further gave a final opportunity to the Government of India, to the Union of India, to obtain the instructions by today, failing which the instant writ petitions will be taken upon merits and disposed of. Now who is appearing? You. Today, when the matter has been taken up, Mr. R.K. Dev Chaudhary, the learned DYSGI, submitted that the order dated 5/10/2023 as well as the order dated 15/11/2023 have been duly communicated to the Secretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion. But there has been no instructions received. Taking into account the above, this court therefore takes up the matter for final disposal on merits. Does anybody have that 97 policy? 97 scheme policy, industrial policy?
No, I don't have it presently.
Dr. Toti, you don't have it? No.
Policy. NEIP policy.
Oh, that my lord,
Not the scheme. the
my
policy.
lord, I don't have that.
This court have duly heard the learned counsels for the parties and have perused the materials on record. Although this court finds it relevant to take note of that although the Northeast Industrial Policy 1997 as well as the Central Comprehensive Insurance Scheme 1997 are not a part of the records, but during the course of hearing, the learned counsel appearing on behalf of the petitioner have placed the same. From a perusal of the Northeast Industrial Policy of 1997, which was announced on 24th of December 1997, it reveals that in view of the continuing backwardness of the northeastern region and the need for a new and synergetic incentive package was widely felt to stimulate development of industries. It is under such circumstances that the Prime Minister made a statement at Guwahati on 27th of October 1996 that new initiatives would be announced for the industrial development of the northeastern region. Expert groups, public committees were constituted by the Ministry of Industry and the Planning Commission to concretize the initiatives. The said industrial policy of 1997 granted various incentives. Amongst the various incentives, one of such incentive was a comprehensive insurance scheme for industrial units in the Northeast would be designed in consultation with the General Insurance Corporation of India Limited, and 100% premium for a period of 10 years would be subsidized by the central government. On the basis of the said industrial policy of 1997, the Central Comprehensive Insurance Scheme 1997 was announced by the notification bearing number 17/1/98-DB-1. The said scheme, the said Central Comprehensive Insurance Scheme 1997 stipulated who the industrial units who would be eligible, as well as the benefit which would be provided. The mode of operation of the said scheme was, as already stated herein above, that the insured shall pay the initial premium, which shall be reimbursed by the nodal insurance company, bracket, National Insurance Corporation, bracket close, out of the revolving fund maintained by that company, full stop. Funds for this revolving fund shall be contributed by the Ministry of Industry, of Industrial Policy and Promotion. Full stop. The petitioner herein, on the basis of the promises so made in the industrial policy of 1997, and taking also into account the various notifications which were being issued, set up its industrial unit in the year 2005. The petitioner thereupon had also got itself registered, as could be seen from the communication issued by the General Manager, IC, District Industries and Commerce Center, Tinsukia, whereby the petitioner was given, was informed that the petitioner's unit was registered under the said comprehensive industrial Central Comprehensive Insurance Scheme 1997, wide number DINCC/CIS/TSK-29 dated 10/3/2005. This court further finds it relevant to take note of that the petitioner herein, on the basis of being registered, duly submitted the said claims, the details of which have been already mentioned in the table, in tabulated form supra. It is also seen that upon the claims being submitted by the petitioner, the amount, the said claims upon being verified by the General Manager, IC, District Industries and Commerce Center, Tinsukia, were forwarded to the Commissioner, Industries and Commerce, Assam. Full stop. What about the earlier two periods?
That my lord, directly it was submitted to the insurance company.
Did you get it?
Yes. That one directly it was given to insurance company.
Then why do we have a period from 2005-6?
My lord, 5, 6 and 6, 7, my lord. My lord, from the petition, my lord, find it directly it was given to insurance company.
Understood. Then why do we find 5-6? Why it has not been paid?
I don't know, my lord.
No, why was it forwarded? Did you submit it to them,
Yes, my lord, it was submitted.
to the national insurance?
Yes, my lord.
Then is national insurance a party?
No, it's not a party.
Then
It probably, let's say this claim was, I'll just check one second.
It was forwarded to my lord.
are you?
Net fee.
Huh?
Net fee, my lord. To net fee, my lord.
Because Netfee has no business then.
Excel 5.
Netfee had no business.
My lord, that is only my lord.
But your submission of the claim should have been to the National Insurance Corporation.
My lord, in fact, my lord, from the report, Excel 5 page 39, my lord, it was
Yes, 13%,
directly
yes.
attached to my lord net fee. To net fee, my lord. Is my lord, maybe my lord.
When?
Is one my lord 10/5/7.
That is what? 10/5/2007 is okay because the industrial policy has come in. But that is the new industrial policy has come in.
2007.
That is why. But what about the earlier two periods? Why was it not given? And why haven't you approached the National Insurance Company?
No, my lord, from the record, my lord, I find, my lord, I don't know.
Because the question of forwarding by the general manager district industry center is foreign out there.
But to net fee, it was sent to net fee, my lord.
Couldn't have it couldn't have been.
Maybe knowing that net fee,
Huh?
maybe knowing by net fee, the disbursing officer, maybe, my lord.
Maybe you may have submitted later on.
No, my lord. It is given there, my
That is why it has been given in 2007-8.
Yes,
You were to submit immediately. Anyways, because
they have submitted later.
you must have submitted later.
Submitted later on because after coming of this scheme, 2007.
Has been tabulated. Here, last line too. This court further finds at this stage to take note of another development which ensured thereupon in the year 2007. On 1st of April 2007, the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, had issued an office memorandum whereby a new industrial policy, namely the Northeast Industrial and Investment Promotion Policy, bracket NEIIPP, bracket close 2007, was announced. In the said industrial policy, various schemes similar to the schemes as was there in the Northeast Industrial Policy in 1997 were also announced. Various incentive schemes were also announced. Amongst the many, it also stipulated that the new units as well as the existing units on their substantial expansion would be eligible for reimbursement of 100% insurance premium. On the basis of the said industrial policy of 2007, a notification was issued by the Ministry of Commerce and Industry, Government of India, dated 27/7/2007, bearing number 10/3/2007-DBA-Roman 2/NER, whereby the Central Comprehensive Insurance Scheme 2007 was notified. As per the said scheme, As per the said scheme of 2007, the designated agency for disbursement of the subsidy was the Northeast Development Finance Corporation, bracket NETFI, the respondent number 5 herein. It was stipulated in clause 6 of the said scheme of 2007, that the NETFI, who shall be the designated agency for disbursement of the insurance premium, shall do so on the basis of the recommendation of the state level committee of the concerned state government. The mode of operation, which was stipulated as per the 2007 insurance scheme, was that the insured shall pay the initial premium, which shall be reimbursed by the nodal agency, that is the NETFI, out of the revolving fund maintained by it. Funds for this revolving fund shall be distributed by the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion. Insurance policies issued by all general insurance company, bracket private as well as PSU, bracket close, registered with the Insurance Regulatory and Development Authority, will be treated as eligible for the benefit under the scheme. In clause 8 of the said scheme of 2007, it was mentioned that in respect of all Inuits to whom the subsidy is disbursed by NETFI / the state government, certificate of utilization of subsidy for the purpose for which it was given shall be furnished to the Central Ministry of Industry, bracket Department of Industrial Policy and Promotion, bracket close, by the financial institution / the state government concerned within a period of 1 year from the date of receipt of the last installment / the full installment. It so happened, from the submissions made by the learned counsel appearing on behalf of the parties, it transpires, parties, as well as the communication dated 10/8/2023 and kept on record marked with the letter X, it transpires that with the coming into effect of the scheme of the Central Comprehensive Insurance Scheme 2007, the National Insurance Corporation, who was the nodal insurance company to disburse the Central Insurance Scheme, to disburse the entitlement as per the Central Comprehensive Insurance Scheme 1997, was done away with. And under such circumstances, a question arose as to how the mode of operation and the disbursement of the amount pertaining to those entitlement under the Northeast Industrial Policy 1997 and the Central Comprehensive Insurance Scheme 1997 could be made. It is under such circumstance, it is under the said backdrop, this court finds it relevant to take note of the communication dated 10/8/2023, which is kept on record and marked with the letter X. It reveals from the communication issued by the Commissioner of Industries and Commerce, Assam, that the Department of Industry and Promotion and Policy had, by the letter dated 15/2/2008, addressed to NETFI, had instructed to consider claims relating to the period from 1/4/2007 under the CCIS, which shall be disbursed on the recommendation of the SLC, in which NETFI, besides others, would also be a member. As regards the claims under the scheme up to 31/3/2007, the existing policy procedure would be followed for disbursement. Subsequent thereto, by another letter dated 23/5/2008 addressed to NETFI from the Department of Industry Promotion and Policy regarding procedure for processing the claims under the CIS scheme, mentioning that the claims relating to the period from 1/7/2007 under the Comprehensive Insurance Subsidy Scheme would be disbursed on the recommendation of the state level committee of the respective state government, in which the NETFI, besides others, would be also a member. As regards the claims pertaining to the period ending 31/3/2007 or before, the procedure of disbursement prevailing as on 31/3/2007 may be followed. It is under such circumstances that NETFI returned 106 numbers of CCIS claims relating to the period ending after 31/3/2007 for recommendation of the SLC. Thereafter, the first SLC was held on 7/8/2009 for consideration of the Central Insurance Comprehensive Insurance Subsidy claim, and opined that in the light of the instructions given by the Department of Industrial Promotion and Policy by letter dated 15/2/2008, the CCIS proposal under the Northeast Industrial Policy 1997 be brought under the consideration of the SLC for claim pertaining to the period from 1/4/2007, and accordingly CCIS claims under NEIP 1997 along with claims under the NEIIPP 2007 were processed for approval up to the fifth SLC dated 1/2/2011. However, during the discussion in the sixth SLC held on 14/9/2011, the chairman raised the question on the authority of the SLC to consider the claims under the CCIS of NEIP 1997 as the Roman one. The policy had already ceased to operate with effect from 31/3/2007. The sixth SLC dated 14/9/2011 decided that the department should take clarification on the matter through DIPP through the state government. Further, a letter dated 12/7/2012 was sent to the Deputy Secretary to the Government of India, Department of Industrial Policy and Promotion, Government of India, seeking clarification. Thereupon, a reply was received from the Department of Industrial Policy and Promotion by the communication dated 23/7/2013, which provided that para 2 of the notification number 17/1/98-DBA-Roman 1 dated 14/7/1999 to be followed, but they did not mention anything regarding the procedure for processing the CCIS claim after 31/3/2007 under the NEIP 1997. Under such circumstances, the SLC decided to process the claim of the Central Insurance Scheme, Central Comprehensive Insurance Scheme under NEIP 1997 only after obtaining proper clarification from the Department of Industrial Promotion and Policy. Thereupon, on 5/5/2014, a communication was sent to the Additional Chief Secretary to the Government of Assam requesting to guide for suitable measures to be adopted for disposing the pending proposals of the Central Comprehensive Insurance Scheme under the NEIP 1997. Later, a query was received from the Deputy Secretary to the Government of Assam. Deputy Secretary. by letter dated 14/7/2014 regarding the committee and the procedure. A reply to the same was also provided by letter dated 2/8/2014. It is under such circumstances, another letter was sent to the Principal Secretary to the Government of India, Government of Assam, dated 4/3/2022, requesting for obtaining clarification from the Department of Policy. What is this? DPPIT, what is that? Department of Policy, Promotion of Industry and Internal Trade, so that the pending 111 numbers of claims of the comprehensive insurance policy and under NEIP 1997 can be settled. However, there was no clarifications received from the Department of Promotion of Industry and Internal Trade as well as for industry. It is under such circumstances, this court passed orders on 5/10/2023 as well as 15/11/2023. However, the Union of India have failed to respond to the said instructions sought for. In the backdrop of the above, the issue which arises before this court is how to resolve an issue. In the backdrop of the above, if this court takes note of the claims which have been made by the petitioner, it reveals that the claims pertaining to (14/7/2005) to 13/7/2006, which is an amount of rupees 79,344. And the subject matter of WPC number 1307/2017 was a claim which the petitioner ought to have approached the National Insurance Corporation as per the Central Comprehensive Insurance Scheme 1997. As regards the claims pertaining from with effect from 1/7/2006 to 13/7/2007 of an amount of rupees 1,13,300, which is the subject matter of WPC number 1304/2017. The said claim partly falls because the insurance is taken before.
The premium paid scheme is there on page 38, Lordship will find. It was paid on.
The petitioner herein also ought to have approached the National Insurance Corporation, taking into account that the premium was paid prior to the coming into effect.
25/7/2017.
So they 25
25.
They paid later on insurance.
25, 7.
How can they pay later on after the period is over? No.
No,
It
Lordship,
can't
I
be.
only say the pays 20, pays 28.
Insurance is paid always before.
Yes, I don't know, but like this is the document, Lordship, where Lordship may find pays 38,
What is 1304?
pays 38. So if the period was from 14/7 to 13/7.
Paid on 25/7.
14/7, 2006 to 13/7, 2007. So they paid the thing on 25/7, 2007. The receipt that they have given, page 38. At the bottom, on the left hand side.
How do you pay the insurance after the period is almost over? Possible? Have you ever heard of? Huh? How do you pay?
What is the text of the letter, my lord?
As regards the year.
6/7. They will verify, my lord, otherwise. Otherwise, also they will verify.
As regards the year also, 14/7/2006 to Iman, amounting to 1,13,300. The petitioners ought to have approached the National Insurance Corporation if the payment was made, insurance payment was made, insurance premium payment was made prior to the Northeast Industrial Policy, not Industrial Policy 2007 coming into effect, and prior to the Central Comprehensive Insurance Scheme 2007 coming into effect. Be that as it may, it reveals that the petitioners made those claims in respect to the period from 14/7/2005 to 13/7/2014. That is a period of 9 years before the General Manager, District Industries and Commerce Center, so that the same could be placed before the SLC, and thereupon the amount could be, upon necessary verification and recommendation, be disbursed to the petitioner. Mr. B.P. Todil, the learned counsel senior counsel appearing on behalf of the petitioner, submits that taking into account that at that relevant point of time, the mode stipulated in the Central Comprehensive Insurance Scheme 2007 mentioned that it will be the SLC who would make the recommendation. The petitioner, on advice, have therefore filed all the claims before the General Manager, District Industry Center, and thereupon the same were duly forwarded on the various dates as various dates. This court, upon hearing the learned, this court, after perusal of the materials, and also taking into account the Annexure X, is of the opinion that if the petitioners are entitled to the said amounts as claimed in the 9 writ petitions for the periods as stated in the tabulated form, the respondent authorities cannot deny the said entitlement or delay the entitlement merely on the basis that there has been no authorization by the Department of Industrial Policy and Promotion Policy of the Government of India, or the Department of Promotion of Industry and Internal Trade, Government of India. Full stop. Taking into account that it was an incentive, it was a policy decision, it was pursuant to a policy decision. Those incentives were announced, and the petitioners, on the basis thereof, have changed their position. And the respondent authorities cannot deny the entitlement of the petitioner. Full stop. This court have also perused both the Central Comprehensive Insurance Scheme 1997 as well as Central Insurance Scheme 2007. It is also an admitted fact that at present, the National Insurance Corporation, which was the manner in which the claims pertaining under the Central Comprehensive Insurance Scheme 1997 are disbursed, is no longer in existence. Under such circumstances, it was the duty or an obligation which is thrust upon the Department of Promotion of Industry and Internal Trade, or the Department of Promotion Industry and Promotion Policy and Promotion and Policy, DIPP. Policy promotion or promotion? Policy and promotion. To set out the modalities by which the said claims which were pertaining to, but under the Northeast Industrial Policy in 1997 could be disbursed. Under such circumstances, this court therefore disposes the instant batch of writ petitions, thereby directing the Secretary to the Government of India, Ministry of Commerce and Industry, Department of Policy and Promotion, to frame the necessary modalities to take appropriate steps for the purpose of
Under 2007, already that committee is there. The only thing is
why I am not going to do that. That is for them to decide.
no, they can. I mean,
To
maybe
formulate.
appropriate decision whom to be given.
Formulate the mode of operation for the purpose of recommendation and dispersal of the recommendation and dispersal of the claims under the Central Comprehensive Insurance Scheme 1997. Which have been pending. As per the Northeast Industrial Policy 1997. So that the said amounts to which the petitioner herein are entitled to, petitioners or other persons who are entitled to, could be disbursed, could be recommended and disbursed at the earliest. Accordingly, this court therefore directs the Secretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, to carry out the said exercise within a period of 3 months from the date a certified copy of the instant judgment is furnished to him. No, within a period of 3 months from today? Yes. No, 3 months. 3 months is okay? 3 months. Full stop. Within a period of 3 months from today. This code further directs that in the said mode of operation to be formalized by the Secretary to the this code further directs that upon the mode of operations finalized and intimated, the agency who have been entrusted to recommend and thereupon disburse the said amount shall do so within a period of 3 months thereafter. Full stop. Mr. Dr. B.P. Todi, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner, further submits that the petitioners herein would also be entitled to an interest in view of the fact that it was on account of the laxity on the part of the respondent department, the amounts have not been disbursed to the petitioner. He, however, submits that the question as to whether the petitioner, whether there could be, the question as to whether any interest could be claimed on the subsidy amount is presently sub judice before the Supreme Court in the case of the state of Assam versus same case
The different maladies
versus Ishwar Food Products Private Limited and others in SLP number
11056.
11056/2020, whereby the Supreme Court
In January, I can fix that.
had directed maintenance of the status quo pursuant to the order passed by the division bench of this court for payment of interest on the subsidy amount. Also, taking into account that the specific question as regards the interest on subsidy is pending before the Supreme Court, this court is of the opinion would not like to pass any directions for payment of any interest at this stage. However, grants the liberty to the petitioners to approach the respondent authorities seeking for to seek interest in the eventuality the Supreme Court decides that there can be decides that interest can be awarded upon the subsidy amount. With the above observations and directions, the petition stands disposed. The registry is directed to furnish a copy of the order of this judgment to Mr. R.K. Dev Chaudhary, the learned DYSCGI, for effective compliance.
My lord, appropriate remedy for it, we can come under 224.
What?
My lordship has directed that to approach the authority.
Absolutely.
My lord,
How will I know interest? Why will you come here?
Last date, Your Honor, had got some clarification on the formalities for auctioning the CGAT, creation of third-party rights. So I have prepared a short compilation of the relevant provisions. All the formalities would be within.
What is this? Copy of this one?
This is the relevant statutes and the rules. I've compiled it in one place, but otherwise it's scattered in different places. Easy for us to refer to.
Somebody has filed an additional affidavit.
That, yeah, yes, sure. The procedure I've also laid out there by way of an additional affidavit. I thought liberty on the last day that I filed it. I think it will be more fruitful to just look at the statute here. Procedure is fully there. I come to page 15 of my compilation. Page 15. The relevant provision here, Your Honor, is 15B. Now, this is the Assam Tea Plantation Provident Fund and Pension Fund Deposit Linked Insurance Fund Scheme Act, 1955. So the 1955 Act. Now, 15B1, Your Honor, is the relevant provision by which attachment and receivership can be made. If I may just read out 15B1, where any amount is in arrears under Section 15. This is the case, a recovery certificate has been issued by them. I have not challenged the recovery certificate. So in a sense, the dues are a fait accompli. And given that this is a beneficial legislation, the workmen have to be paid. There is no shying away from that fact.
Now, what has happened in your case?
So what has happened in my case, Your Honor, is that the tea garden has been taken over almost 6 years ago.
By?
It was first taken over by respondent number 1, which is the DC. And the DC had set up, and there's a separate writ petition pending regarding that. So I'm not going to, I've challenged that, but I'm not going to go into the merits here. But the DC took over the garden by virtue of minutes of a meeting. How that has happened, I'm not sure. There are no provisions of law for it. So it takes over the garden. And once the garden is taken over, he constitutes the managing committee. And he also appoints certain individuals, he appoints the respondents as, he assigns the duty to the respondents to start pruning of the tea bush. Now, this tea garden is almost.
Who respondents them?
Yes, there are 2 sets of respondents, Your Honor. One is the DC Kachar, that's 1, 2, 3. And the second set is the Provident Fund Department, which is 3, 4, 5, 4,
Yeah,
5,
the
6.
DC, represented by DC Qatar. State of Assam is represented by the DC Qatar.
In this case, Your Honor, this is how it's
How many
been filed.
refugees are Qatar?
Because the DC had taken possession, but the main issue,
Now, with whom is the garden?
the garden was with the DC. It has now gone into the receivership of the recovery officer, technically. But there are 2 attachments that seem to have taken place, and this is where I take a little bit of an issue. Now, the attachment, as far as the immovable asset is concerned, there's a due of about 88 lakhs. That's admitted. Now, those 88 lakhs have to be recovered from the sale of the garden. That has to happen. Now, the garden is 1,000 hectares, of which about 477 hectares are planted tea bushes. So the law says that under Rule 52 of the Schedule 2, I'll come to, essentially any portion of the garden that is sufficient to defray the arrears can be sold. But a second attachment seems to have also have taken place where.
Are you saying that the garden can be partly sold?
The garden can be
partly sold?
Yes, Your Honor. That is what the provision is.
Of
the rule. Your Honor, I have page number. So if I may just show page first, the provision that brings in the Schedule B, the second schedule. Your Honor, I have page number 19
of
my compilation. Everything's there.
Oh, this is your compilation.
That's correct. I put everything here, so we are transparent. So 15G is the relevant one. Page 19.
Yes.
15G, the provision of the second and third schedule of the Income Tax Act, that's number 1, and the Income Tax Certificate Proceeding Rule, 1962, as in force from time to time, shall apply with such modifications as may be necessary for the application to this Act, as if the said provisions and the rules are referred to the arrears of the income tax, arrears of the amount mentioned in Section 15 of this Act, instead of the Income Tax Act. Provided that any reference in the said provisions of the Income Tax Act 1961 and the rules to the word SSC shall be construed as reference to an employer as defined in the Act. So that's fairly clear, Your Honor. Now, Your Honor, I have page 31 of my compilation. Now we jump to the second sheet. Page 31.
Yes.
On the page 31, part 3 is the relevant portion. So in some, the answer to your Honor's previous query, what is the formality, will actually come from this part. The entire part 3 is a detailed code. So the attachment has now taken place under 48. Sorry, I apologize, Your Honor. Yes, under 48. Now 48 is for attachment of immovable property. I pause here for a minute because an attachment of my business has also taken place, which is different from attachment of immovable property. So now 48 and the order has been passed under 48, attachment takes place, service has taken place, proclamation I believe has taken place. These things have not been challenged. Now I come to 52. This is what I'm relying on. 52 says sale and proclamation of sale. The recovery officer, it says tax, but we'll read it as recovery officer. The recovery officer may direct that any immovable property which has been attached or such portion thereof as may seem necessary to satisfy the certificate shall be sold.
Understood. Well, Mr. Counsel, this is a tea garden. Tea gardens can't be partly sold. That is the problem. You see, that is why I'm saying I asked you the specific question. These are tea pattas. These are leases of 99 years being given.
I agree. Your
And these are being very well, these are lands of special cultivation, which are along with that particular, you can't part with. Half of the tea garden will do it, half of the, no. Therefore, part of the tea garden cannot be sold or attached, or what you call, the sold. Because then you will be saying today, because what has happened, you are saying that 1,000 hectares of land is the garden is there and 477 hectares is under plantation.
Correct.
The moment you are saying that, the government will immediately take steps under the Assam Fixation of Land Ceiling Act and say that, okay, 477 is there, leave alone another 5, as per section 5, another 100 hectares of land, more, and the remaining will take over under ceiling. The entire land will go. Not such a simple thing which you are saying.
I'm only trying to reconcile what this says, Your Honor, because if it is sufficient,
These are being done. I know this, the second schedule of 19, these are done under the income tax 1962. But that is a power which is being given. But the fact that they are not in a position to sell part of it, either the entire garden is to be sold or half part or not at all. Because a garden can't be partly sold.
I agree on. I will have to look into that. I do not have something on that.
So this is
Nor do I have the knowledge.
that is why I asked you, how is it possible?
Very well. Now, pausing here for 1 minute. So, the second situation, Your Honor, that
Anyways, the question arises is, how do you pay the remaining amount? We are on that. Not on
that
this
answer, Your Honor,
stage.
lies in 15B. Sir.
Huh?
That answer is in 15B. Sir.
15?
15B.
B.
15B of the 1955 Act at page 15.
Page 15.
Yes.
Yeah.
Page 15 is actually the proviso. So, it'll, if you want to turn to page 16 at the top.
Attachment and sale of the movable or immovable property of the plantation, or
These
as
are
the
the
case may be, the employer.
Arrest of the employer
Arrest
and his
of
detention in
the
prison.
employer and
Appointing a
his
receiver for
detention
the
in prison, appointing of a receiver for management of the movable or immovable property, or as the case may be, the employer.
Now, this is actually the answer.
Huh?
Provided that the attachment and sale of any property under the section shall first be affected under the properties of the plantation, and where such attachment and sale is insufficient for recovery of the whole of the amount of arrears specified in the certificate, the recovery officer may take such proceedings against the property of the employer for recovery of the whole or any part of such. So this is the waterfall. So first, the plantation has to go. So in my respectful submission, I'm saying that part of the plantation. If that is not possible, then the entire plantation will have to go.
So therefore, they will appoint a receiver.
The receiver has been appointed. Receiver has been appointed. So now there's an issue with the way that the receiver has also been appointed, because admittedly the certificate that has been issued, the recovery certificate has been
No, my question therefore, or you should be in fact urging, is if you have appointed a receiver, taken recourse to the action,
yes,
you have to make it very clear as to what are the things which you are getting, so that my amount which I am paying to you, I know what is happening.
Absolutely. No, absolutely. This is actually what I've said in my
In fact,
additional
as I
application as
could
well.
know from here, they just appoint somebody. And then there is nothing shown out there as to how the amount which is being received from the receiver
Correct.
is then applied to the dues.
Absolutely correct.
Because you cannot keep the receiver all the time. You are taking over my entire business. Once you take over my entire business, obviously, you are to show me how you are doing it so that the amount which you are receiving or whether the receiver at all is paying the right amount.
Absolutely. All these provisions are here and I'll point them out. I've actually marked them here. So the receiver has been appointed under Rule 70. If your honor may have page 70 or page 17 of their counter affidavit. Just one document. Page 17 of the counter affidavit. It is actually the document by which the receiver has been appointed. So first the attachment takes place, subsequently a receiver is appointed. The date of the receiver being appointed.
Is the receiver a party to the instant proceeding?
No, madam, that is actually my objection, my lord. Till now, they have not impeded the.
But the
receiver, my
receiver
lord.
works under the recovery officer who has been made a party.
Understood, but what he's doing, there is an agreement entered into.
Yeah, ma'am.
But can this court today, a right has been created by them in favor of him for a particular
correct.
period of time.
And in fact,
But
he's also liable for losses and
Absolutely.
Yeah.
And for which they, if this court holds their action to be bad, that will also affect him.
Yeah.
Then
Plus attachment of his property is also possible. That is the receiver has not been appointed.
bro, what to do?
Give me some time to appoint the receiver, to complete the receiver. Complete the receiver in this proceeding.
The learned counsel appearing on behalf of the petitioner submits that taking into account that the receiver have not been impleaded as a party to the instant proceeding and any direction part here he would like to take appropriate steps in that regard so that the said appropriate to list the matter. When do you want it? Who has the urgency?
I have the urgency on
Fantastic. You want it this year or next year?
this year, preferably I'll file the application within a week.
Which year? This year?
Yeah.
Have it on 11th? 11th of
Obliged.
Twenty-two.
Yes.
22, Lordship, we have been directed to receive certain instructions, Lordship. But yesterday, Lordship, we have received one letter from them, Lordship, requesting us to make a prayer before Lordship for certain accommodation. But
No affidavit filed.
we are filing it during the course of the day. PNRD department is filing it
You.
Lordship, yes, Lordship, we have received one letter.
You are
from the-
exercising 18.
Lordship.
Under what authority?
No,
If the
Lordship,
land
in
was
that,
was the land a government land or was it the
yes,
Panchayat land?
Lordship, in that, the letter which we have received requesting us to make a prayer before our Lordship for an accommodation. But in this letter itself, Lordship, we are getting some instructions. That instructions, I think, that the queries your Lordships made, Lordship, that that third line, Lordship. Further, it is to be informed that the land covered by DAG number 7.
So it is a land, it's a purely government land.
Lord. Even as per our instruction, it is covered.
So Rule 18 can be very well exercised.
Lord, that is right. The queries made by your Lordship is there in the letter itself.
So what right does he have? This is eviction against what? You allow the petitioner to carry out his business in the petty number Iman and be pleased to pass You are carrying on what business, Mr. Council?
Shop.
Shop. Shop for what?
Perhaps,
Okay.
close that.
Now, this is a common land.
Yes, definitely.
How can you be in occupation of the land?
This market was established in 19.
What is your right? What is your right over the land?
Over land, I have no right. But
Okay.
but
Petty?
there is a market.
Understood, petty? What right?
For running a market, the regulatory authority is the panchayat. Right. So someone entered in the market to do business, have some authority from the
Panchayat.
panchayat. So my entry, I am not encroaching that. If the concept of encroachment applies in the market, then nobody can go in the market. But
And is it selectively applied to him or others?
no, actually, in this case, the background is to evict two shops for some vested interest. The 19 or 20 eviction notice were issued. The eviction was carried out to evicting those 2 persons.
You have been evicted?
No, I am not evicted. But since this notice is survived matter, the eviction.
Or they have fulfilled their desire? They have fulfilled their desire to evict those 2 persons.
Yes, ma'am.
Now they may not like to evict.
Yes. There is no requirement for the government of the land because the market is there.
This notice
And
has
rule-
been issued by the SDO, man.
Yes.
That is the prayer application, Lordship. In that, Lordship, this line I have found, Lordship. The queries your Lordship has made. Because of that, this 18th notice
least
was
my lord-
issued.
Rule 18 to
No,
cannot be-
he cannot claim that he should be given that place, Lordship. In
No,
the
he
market, he
cannot.
can be
He-
given
He
another.
cannot.
Lord.
You can pull him up.
Lordship,
But if your actions are
Lordship, selective.
let's say,
Lordship.
and his basic submission is your proposal was only for to throw out this A and B,
Lord.
and you have already thrown out. Why now? And it was only to show that it was equally applied to everybody.
Lord.
The petitioner was one of the persons, isn't it? Earlier affidavit.
I think by
Mr.
Lanet, very nice.
escape.
Mr. H. Sharma appearing on behalf of
But
the
yes, interim is there, Lord.
appearing on behalf of the respondent, District Commissioner Hosai, submit that he has received some instruction to the effect that the land in question is a government land. However, in the instruction, 2 weeks' time have been sought for the purpose of filing the affidavit. Taking into account the above, this court fixes the matter again on 13th of December 2023. In the meantime, the affidavit be filed by the District Commissioner, Hosai, by the District Commissioner, by this court further have also taken note of the instructions so produced by Mr. N.K. Devnath, the learned counsel appearing on behalf of the PNRD, who submits that the land wherein the petitioner is in possession is a government land. And as such, the action so taken by the respondent authorities was well within the powers conferred upon them by Rule 12 of the settlement rule. Taking into account that this court had directed the district commissioner to file an affidavit and fix the matter, the interim order passed earlier shall extend it till the next day. But in no case, I have already finished my quota of disposal, so I am not.
23.
Oh, that one. Mr. Sharma, This matter you appeared on the last occasion. I asked you as to whether petitioner will be entitled to under the NFSA. The other aspects, okay, they say that in one aspect, 2000 they have got it and the other they are not. But as regards the NFSA, there was some amount to be paid, they are claiming.
Yes. That's like 4.
Yes, Lordship, I remember, Lordship. File 29.
It's a very small amount for which the petitioner is.
Lordship, Lordship.
Yes, Lordship.
The cost of the petitioner and the appearance of the petitioner must have expended more. Yes.
This
Lordship,
proposal has been provided.
may I pray for some time, Lord?
Okay. This is the matter on 4th of December 2023, on which date Mr. H. Sharma shall ensure that the instructions sought for by the order dated 15/11/2023 is received.
Time may be allowed for filing affidavit.
Why? 2017 matter, you want 2 weeks time?
Sorry.
What is your instruction? Yes, madam, what are you asking for?
This is also put under the NFSA, the assistant lordship, and she was, because there are 2 schemes of the government. One is the JSY. When the pregnancy is detected by the ASHA, it has to be registered under the JSY scheme. Then she is entitled for checkup, pre-checkup. And there is another one scheme, JSSK scheme. So under that scheme, lordship,
We fix this matter along with the other one. The same instructions will be there, similar instructions.
one will be with regard to health department, one will
One
be
with NFSA.
yes.
Where is Mr.
WCD
H. Sharma? He has gone. Who is appearing for the government? We don't need two councils for similar type of matter. This is only the issue with the matter along with it to account matter to look at. Man. On the next day, on which date the respondent shall obtain the necessary instructions as regards the entitlement. You get your instruction, madam. That is enough. You don't require the affidavit for all. Nothing. Whether he is entitled or not. You say that the Mamoni scheme would not be applicable because at that time the scheme was not there. I think that is your instruction.
May please, Lord, but as per the last relevant order dated 13/10/2023, my
Pay
lord,
the deficit co pay.
my lord, we have
Has not been received. Oh my goodness, I should dismiss it now. Return the petition on the ground. The deficit
my
could
lord,
be.
my
When?
lord, by tomorrow,
Tomorrow, along with a cost of 5,000.
my lord, I will pay.
What? Why haven't you paid?
My lord, we have established contact, my lord, there is some difficulties in the part of the petition.
Have you taken the land for acquisition?
Lordship, some, yes, we have taken, and compensation are also paid.
Paid?
In some cases, they are clubbed together all they are probably 38 or 39 petitioners. Some of them are occupying government land, some of they are.
Whatever may be, what is your instruction?
No, we have
Hey,
not-
government land, they would not be entitled to the land compensation, they will be entitled to the Jirat.
Right.
Have you paid the Jirat?
Jirat, there was no Jirat at all. In our survey shows that there are no Jirat.
So there was no Jirat. So whoever it is, I think you need
have
to
paid.
file an affidavit.
We have,
You file an affidavit here. Oh yes, affidavit filed. Hello. Taking into account that the petitioner have not paid the deficit court fee pursuant to the order dated 13/10/2023, a final opportunity is given to the petitioner to pay the deficit court fee on or before the next date. List the matter again on 11th of December.
One more. Here, there, if making party, national highway authority BTA. Your submission is this, that we have not contacted national particular, we have that particular, we have not contacted. Now, if for adjudication.
You have filed affidavit.
No, no. That, that is,
I cannot,
Yes,
on
I
the
will
basis
affidavit.
of oral submission, sorry.
Okay. Yes,
26.
I'll file.
Made Vijala. My lord, what had happened in this case, the same complaint is being examined by my lord pre-authority. As far as CID is concerned.
Oh, that I remember. Yeah.
CID has
And in
given a
fact, I
report
directed
saying-
them to file an affidavit. Yes, what
Definitely,
happened?
Yes, my lord.
Why haven't you filed an affidavit? He appeared for the CBI or something.
5 and 9, my lord.
5 and 9. Pending
Anti-corruption
so
law.
far as it relates to the respondent number 5 and 9. Direct the said respondents to file the affidavit.
My lord.
Who is 5 and 9?
My lord. The corruption is appearing, my lord. Something.
Anti-corruption?
Vigilance
Superintendent
and
of police.
anti-corruption.
Okay. We direct their personal appearance.
My
They have
lord.
not filed the affidavit. They are delaying the procedure and thereby he is put into harassment.
Yes.
2 proceedings he have been given a clean sheet. Only 1 proceedings it is remaining. And that is why I have asked them to file an affidavit. And nobody is appearing. No affidavit filed. Okay. Today, when the matter has been called for, it is seen that not only the respondent number 5 and 9 who have been directed to file the affidavit by 15/11/2023 have not filed the affidavit. The counsel who was representing have also failed to appear. So this court fixes the matter again on 6th of December. Full stop. It is made clear.
After 5, 6 and 7.
Okay. Let it be when I am there
Okay, my lord.
on 18th of December.
That suits me also.
18th of December 2023. Full stop. It is made clear that if no affidavit is being filed by the respondent number 5 and 9, this court shall dispose of the instant writ petition on the basis of the pleadings which are available on records.
If
Yes, who is appearing for those respondents 2, 3, 4? There was a collusion between them. Isn't that the case, Mr. Chaudhary?
Yes. Chief, we have already informed the chairperson of the Nalbari Municipal Court.
Who is you are paying for?
I am instructed to appear for respondent number 4, Lordship. Today I have received Ukalat number. I have yet to file Ukal number.
Now the question here is regarding cancellation of mutation,
Yes.
if I am not wrong. And the respondent, the person who cancelled the mutation and for whom it was cancelled, all were together appearing.
Yes, sir, Lordship. I am instructed to appear on behalf of respondent number 4, Lordship. Today I have received Ukal number.
And who is appearing for 2 and 3?
I.
You have informed?
Lordship.
How?
Letter, Lordship.
How? Put it by way of an affidavit.
Lordship.
Is there a stay operating, Mr. Chaudhary?
There is no.
No stay? This is against the mutation order.
Yes.
Hello, we do one thing. We fix the matter again on Mr. What's your name?
Arsha
Sharma appearing on behalf of the respondent number 2 and 3 submits that the said respondents have been duly intimated by the communication dated
16/10/2023.
15/10/2000.
16.
16/10/2023 that they would not be further appearing in the matter. Ms. P. Bhattaji, the learned counsel, Mr. Ms. P. Bhattacharya, the learned counsel, submits that she now appears on behalf of the respondent number 4. Full stop. Taking into account the above, this court is of the opinion that as the respondent numbers 2 and 3 are presently not appearing, have not appeared. Full stop. This court grants a final opportunity to the respondent number 2 and 3 to appear in the matter. Full stop. List the matter again on 13th of December 2023.
Case, my lord, I have received the instruction, my lord. This is forest land, my lord. I have received the instruction, my lord. May I place it, or my lord, I'll file affidavit, my lord.
Forest land.
Forest land.
Forest who is appearing?
Hello.
Yes.
I am appealing. I have a set of instructions. My lord, I can go through.
I
Yes,
have
my
also
lords.
scheduled my lord.
They are, my lord, assailing basically an inaction of the DC who have cancelled their pata. In this instant case, my lord, report has come that they are within the PRF.
Huh?
They are within the PRF, which is going to be notified very soon.
PRF.
Proposed reserve forest, which is going to be notified very soon, and they can also submit their claims if they want or desire so. If so advised.
Affidavit may be allowed to file lawsuit. I'll reply, man.
Now, when was the notification issued under Section 5?
Lordship will see that it's that is not there, man. So this under process. It's under process.
How is it possible? Section 4 or 5, that notification has to be issued. Once that notification is issued, then it is only said that it is proposed to be in the PRF.
It's
The
my
final
it's
notification will
mentioned
be
in
issued subsequent.
It's mentioned in the letter, man. 1959 minutes.
The resident is notified by the government by Iman. The final notification will be issued after proclamation notice as per Section 6 Iman. So as of now, for the last 65 years, we have not passed the final one. Then what has the value? Thank goodness.
And now, my lord, some PILs have been moved in this court, wherein my lord, slow motor PIL has been also taken as regards forest of Gwalpara. So, my lord, their directions were passed to, my lord, take steps to reduce human-elephant conflict and also to take
Your
protection.
Khatian was cancelled.
Yes, his Khatian was.
My lord, my patta was cancelled, lord.
Fantastic. You do one thing.
My lord,
Your
there is-
patta was cancelled by whom?
by the deputy commissioner.
What is the business of the deputy commissioner?
File affidavit. We'll file affidavit.
When? I've directed you to file the affidavit.
I have
Mr. D. Gogoi, the learned counsel, appears on behalf of the Forest Department and submits a set of instructions wherein it has been mentioned by the Divisional Forest Officer T. Gwalpara that the Rajyasini PRF, Rajyasini PRF is notified by the government notification number FOR/SCTT/484/58/372 dated 23/10/1959. And the final notification as RF would be issued after proclamation notice as per Section 6 of the Assam Forest Regulation 1891. It has also been mentioned that any party who has any claim over the said proposed reserve forest can make the said claim before the forest settlement officer. Full stop. Be that as it may, the said instruction is kept on record and marked with the letter X. Ms. Yudas, the learned additional senior government advocate, submits that the para-wise comments have been received. This court have looked into the same and finds that the said para-wise comments should be put by way of an affidavit. Full stop. It is also said list the matter again on 15th of December 2023. The affidavit be filed by the District Commissioner, Gwalpara, by 11th of December. The petitioner, if so advised, would be at liberty to file the reply.
My lord, copy of the instructions was submitted, my lord, that may be available.
Nothing is there. I've already recorded what it is there. The other one I have returned it. I'm not looking into it. This instruction I've already, that it has been there by that particular year. Nothing more than
That
that.
is negated by the learned civil code in an appeal law.
Whatever may be, that is what he has said. I've kept it on. You want to take certified copy, take a certified copy.
Yes, sir. All right.
Or Mr. Gogoi, give him a copy. Let him be happy.
I can give it.
Yes, next.
Good night.
Oh, this one.
এখন কি লেলো না এখন কেউ গিয়েছিল
মুখ কোনে দিছে
কেউ গিয়েছিল আপনি লেলো
Made this a lordship. This is regarding non-payment of
this pilot I have to take some
Oh, did you get the
steps.
money?
No.
Why?
Pilot knows there's a constraint of funds, so it's under process.
Fantastic.
Pilot will fix it after a
We
week.
asked the
pilot.
commissioner and secretary to PHE to be personally present for non-compliance.
Perhaps my chief engineer would suffice
No,
after a week.
no, their direction was to commissioner and secretary. To the PHC department is directed to
My lord,
disburse the
some
amount of
process may be
28
on.
lakhs to the petitioner on or before the next day.
Some process may be on. My lord, I may be granted 2 days time. I will
2
bring
days?
whatever it's going on.
Okay.
2 days or my lord, next week.
Ms. M. Hazarika, the learned senior counsel, appearing on behalf of the petitioner on instruction, submits that in spite of the order passed by this court on 27/9/2023, and there being a specific direction to the commissioner and secretary of the PHE department, the amount of rupees 28,80,804 has not yet been released to the petitioner. Mr. D. Gogoi, appearing on behalf of the respondent, submits that some more time is required for the purpose of making the payment. Be that as it may, this court, taking into account the order dated 27/9/2023, and there has been, and it has been duly accepted that the respondent department is liable to pay the said amount as far back as on 29/10/2021. This court is of the opinion that a final chance is granted to the commissioner and secretary to the PHE department to disburse the amount as directed in the order dated 27/9/2023. On or before the next day. When?
As the lord.
Leave it to lordship at least 15 days, man.
Huh?
15 to 10 days, man. 15 days, man.
Today is 24. 22nd. Okay. 13 December.
Man.
It is made clear that in the circumstance the said amount is not clear, this court would have no other option but to call the personal appearance of the secretary, PHE. 30. Yes.
My lord, this writ petition is pertaining to settlement of fishery, my lord, number 22 Laipulia fishery under Dhemaji district, my lord. Lordship, page number 37, comparative statement may be seen, my lord.
Affidavits filed.
File, my lord. Writ petition,
What
my lord,
remains?
Page 37 of the writ petition.
Got a stay. Have you got a stay or not?
No, my lord.
What do you want?
My lord, I pray for disposal because, my lord, the petitioner is deprived by not settling the fishery with her, my lord.
In the
But the
light
illegal-
of the minute and shall not be set aside the impugn order whereby the fishery is illegally settled to respond number 5. Who is
Well,
respond number 5?
Uh,
Where is he?
Respondent number 5 is the, my lord, caveator, my lord, for my lord, appeared earlier occasion, my lord, and they are given the settlement, my lord, we are suffering, my lord, because we have been deprived, my lord, as per page number 37.
So we required to quickly dispose of the matter.
My lord, this is 2020 matter, my lord. So, my lord, I pray, lordship, only one page may be seen, my lord. Case is very much clear, my lord.
Understood, but I don't have the time for today. If I have the time, I would have.
My lord, our
And you
our
see,
channel is very much
there's a
clear
very
and
less
very
of
much.
time. Tomorrow,
My lord, next Wednesday, my lord, if it is there, my lord.
Wednesday not. Okay, we do one thing. The learned counsel appearing on behalf of the petitioner expresses urgency in the matter, taking into account that almost 3 years have passed by pursuant to the issuance of the contract settlement in favor of the respondent number 5. Be that as it may, as the respondent number 5 is not represented today, this court fixes the matter again on 28th of November 2023 at 2 p.m.
My
for
lord,
final disposal.
maybe 29, my lord.
No. So then
29 or 30.
leaves the matter on 4th of December.
Sorry, my lord. sorry, my lord.
Sorry.
My lord, 28.
32. I don't have time. You see, I can't impose upon my fellow judge because I won't be sitting from 4th till 15th. Yeah. So I can't impose upon my fellow judge. So,
It is the earlier date, my
sorry.
Earlier date, maybe.
No. Okay. Next. It will be on 4th. Yes, Mr. Ghosh.
With regard to the settlement of.
Pleadings complete.
Pleading is complete, Lord.
Okay. We'll fix it in the next year for disposal.
A date may be fixed, kindly, Lord.
Okay. List the matter. Second. List the matter on 4th of January 2023-24, on which date an attempt shall be disposed of the matter.
Earlier date can be fixed. It's up to Lordship, my lord, but
I can't impose upon my fellow judge. I can't ask them for disposal. An attempt shall be made to dispose.
34.
Yes.
Lordship. My son had expired.
Lordship, my lord,
drowning
in
in
last
fire.
occasion, I was directed to my lord, file affidavit. Affidavit I have been prepared, Lordship. The one instruction I have received, Lordship, kindly follow the instruction.
What is this? This is pertaining to?
Payment due to drowning in fire.
Huh? Or drowning?
Drowning.
As per their complaint due to my lord, their death of the due to flood, Lordship. And Lordship, as per my instruction, it is not due to death by flood, Lordship.
Mr. J. Hendig appearing on behalf of the Respondent's Revenue and Disaster Management Department
I
has
am appearing on behalf of the state, Lordship.
of the respondent state submits that he has received an instruction to the effect that the petitioner that the reasons behind the death of whom?
Petitioner's son, Lord.
Petitioner's son was not on account of a disaster, but on account of his own accord, as informed to him on the basis of an instruction issued by the Circle Officer, Bhopal Revenue Circle. So taking into account that the said aspect duly touches on the merits for which the petitioner has to be given an opportunity for filing a reply, this court directs the respondent authorities to bring the said aspect of the matter by way of an affidavit. List the matter again on 15th of December. The affidavit be filed by 7th of December. The petitioner would be at liberty to file the reply, if any, by 13th of December.
36.
But the copy may be given.
Affidavit file.
Obliged.
Yes. Non-payment.
Yes, my lord.
List the matter tomorrow at 2 p.m. for final.
37.
By the order dated 10/11, the municipal authority was directed to produce the record with the tender. In fact, this is-
Pertaining to the dispute involved in the present and produce the same before this court for it. We cannot allow given up the June notice take advantage of getting it. Who is appearing for Tezpur? You are.
No, madam. I am for the private respondent. They have not appeared, my lord, despite service of.
You were supposed to produce the records.
Yes, my lord, I have received today, my lord.
Yes, what is this record business?
But the tender was awarded, my lord, to the private respondent, my lord, when there were 4 bidders, all had submitted the same amount as per the bid in the NIT, my lord. And there is nothing in the NIT or any other material on record to that why he was awarded the tender. And
His
then
name
they-
started must have been with A. Huh? I see. Yours is A. You should have got it then.
Look, the
My lord, in identical beats, my lord, ultimately it was found out during selection, my lord, it was seen that this person who was awarded with the tender, my lord, he had suffered some physical deficiencies and he was more suitable for the work. And that is why he was given the work.
He had some
Physical deficiencies.
and therefore he was more suitable.
They thought that he was more suitable.
Can't be
for the
both
work.
together.
absolute arbitrariness, my lord. Writ large, my lord, the arbitrariness is writ large.
Arbitrariness is not there, my lord. Arbitrariness
Where there is
not
nothing
there
in
at
the
all.
NIT as to any preference is be given to
In an NIT, my lord,
Is the matter tomorrow at 2 p.m. for final disposal.
Roger. Get it.
Produce. Mr. Swenso shall produce the records on that.
at 2 p.m., my lord.
The matter pertains to settlement of a minor contract area, my lord. The petitioner is aggrieved by the illegal rejection of his technical bid, my lord. And the
Got a stay.
my lord.
Have you got a stay?
My lord, there's an elaborate order, but no stay, my lord. They were asked to call get the record.
May I make, I'm for the private respondent. my lord. My affidavit is ready. I just need 1 or 2 days time. I'll file it. So,
Okay. The level counsel, Mr.
yes, Mr. Karma.
Appearing on behalf of
Respondent
the
number 5.
respondent number 5 submits that the affidavit in opposition of the said respondent is almost ready and would be filed in a day or so. Accordingly, list the matter on 4th of December 2023.
Can it be on 6th? my lord? Courts, there is a difficulty on my part on 4th. my lord.
On 6th of December 2023, the affidavit be filed by 28th of November 2023.
DP of like, my lord.
39.
Petitioner, if so advised, would be at liberty to file the reply. Yes.
Settlement of market matter.
Settlement of?
Market matter.
Got
By
a
the
stay?
municipal court matter. Although honorable court directed by order dated, my lord, 19/6/2013 to produce the record, my lord. But on the last officer also government official took time to produce the record, my lord. Private
We have
record has
received
also
record,
appeared,
my
my
lord.
Hmm?
We have received record.
Record received.
Yes, ma'am.
Then what to do? Today, no time. I would have taken it up, but today, no time for it. We'll fix it on 28 to 8. There's the matter on 28 November 2023 at 2 p.m. for final disposal. Mr. So-and-so, your name? Mr. Counsel, your name?
M. Satyamal.
So-and-so appearing on behalf of? You're appearing on behalf of?
1, 2, and 3, my lord.
1, 2, and 3 shall produce the records on that day.
40.
Yes.
Reading the over cases, my committee got suspended thereafter. I preferred an appeal the cancellation order. Only the allegation is that delayed delivery. It's not the case that I have not delivered. Delayed delivery.
What cancellation?
My license got cancelled. My license got cancelled.
FP,
Malad,
fair price.
It's a Shomaboy Shomiti, fair price. Shomaboy Shomiti, it's a cooperative society.
Under the 82 order.
My lord, my lord, my lord.
This is done under the 82 order. Then what do you want?
Well, I prepared an appeal. I appealed, my lord. Pleadings are over. My lord, if your lordship goes for a
Pleadings are over.
pleadings are over.
Okay. Taking Mr. P.K. Roy Chaudhary, Learned Council submits that the pleadings are over and there is an urgency in the matter, taking into account that the fair price shop of the license of the petitioner have been cancelled. This court fixes the matter again on 7th of December 2023.
That day I not be there, but not on 7th.
Okay,
Any
very
day
well.
earlier or earlier.
On 14th of December 2023. In which state an attempt shall be made. No, it's not like. Yes.
This is a tender matter, otherwise the pleadings are complete. But
No urgency.
My lord, there is urgency, my lord. Stay order is operating against us.
What is the tender for?
Construction of a boundary wall, my lord.
Huh?
Construction of a boundary wall. It's the Indradhanush gas grid project, my lord.
Okay.
For the pipeline, we are laying the pipeline.
Oh.
There is a stay order operating, my lord. Civil work. This is the best time for doing the construction.
Yes.
Urgency on our part.
Understood, but thing is, no time.
Today, my lord, it may not be
No,
possible.
today we are not asking.
On 28th or 30th, my lord.
30th, Mark. 28th, I have some personal.
You file a stay vacating? No.
No, man.
No. I'll go to again.
30th it is.
Thirty.
Diploma.
Release the matter on 30th, 30/11/2023. On which date an attempt shall be made to dispose of the matter, taking into account that there is a stay order operating in the matter.
The interim has to be acted.
Interim order passed earlier will continue till then.
Till then.
Next 42 May, my lord, there
Any
is
petition,
a.
Anna?
Here are the stay order is operating. Here also stay order is operating. Okay, 33 on.
Naturally, they will have, my lord, urgency. I am not disputing. Only thing is, my lord, the term is already stands extended to 31/12/23. So, my lord, in December, later part also it can be done.
No, because
No, I'm saying-
we have to increase the
No, he took the chance of, you see, if these matters are to be taken up by me, I've fixed all the matters. I don't have now. I'm living on 4th. I have no time.
Before
From
that,
4th to 18th, I'm not there. So it would not be possible. I can't fix this matter and or put the burden upon my fellow.
before that, before
Huh? 5th.
before
5th of December.
no, prior to 5th of 4th,
4th.
on prior.
He wants prior to 4th of December.
It's not possible. I don't have date. No time. You
On
see.
30th,
Huh?
on 30th.
What? The Learned Council appearing, Learned Council
Let it be on
responds
18th.
and submits that there is an urgency in
On
the
18th,
matter.
my lord. 18th December.
I'll pick it in those 2 weeks.
Ah.
Submits that there is an urgency in the matter, taking into account as there is a stay order operating. As such, let the matter be listed again on 5th of December 2023.
My lord, 5th, 6th, 7th.
Okay.
Any day
Then
other than.
on 12th of December 2023, an attempt shall be made to dispose of the petition. State.
Interim order has to.
Interim order passed earlier.
43.
Meeting any urgent matters? Because I have a meeting today. Yes.
Only vehicles have been confiscated by the forest department. It has been auctioned, we purchased it. Now the RTO is finding it difficult to register it because the vehicle is from Rajasthan. And there, my lord, some loan default is there. Then there is a blacklisting order. So therefore, the petitioner is in a fix. So unless they give us registration, they will have to give me the money along with interest. So they are unable to register it.
So what do you want?
Well, that's because the proper instruction has not been given by my learned friend. So whether it can be done certainly or not.
Malad, the blacklisting can only be lifted by the parent RTO. That is, these vehicles are of UP and Rajasthan.
And load is there. It's parent state of.
Understood, but how can this court solve that problem now? I'm asking you, what is the urgency? Is there any interim order till date?
No,
in some matters?
No, man.
66. Your matter is item? Item number 44, list the matter again on 11th of December 2023. Interim order passed earlier shall continue till then.
The pleadings are complete.
Okay.
I'll be highly obliged if your lordship takes it up. The matter relates to awarding of contract by the railway authority. I was the lowest bidder. That's my pleading.
Is there, you have got an interim order,
I
no?
have got it.
So it's okay. Let it be on 11th
11th of
December.
apply.
This-
Let it now.
11th
Earlier
only.
interim order may kindly be.
I've said the interim order passed earlier shall continue till then. Yes, anybody else? 66. 66. What is that interim order? What is that interim order for? List the matter again on 8th of December. Interim order passed earlier shall continue. Interim order passed earlier shall continue. भाई फिर कोई लोग होते
Item number 52, interim order is separate to date.
Item number 52, list the matter again on 13th of December. Interim order passed earlier shall continue.
Item number 48, 51 and. May I say that?
Sorry, Lordship, it is item 50, Lordship. Item is 50.
Very difficult.
50.
Don't make this level. Sorry, I'm not going to accept.
Lordship,
You file an I because this is what you are doing. Sorry.
I'm extremely short.
No, I'm not going to.
Item number 48, Lordship.
Okay, do one thing. Did it a fixed query for? First,
I have
check it out as to whether there is an interim order, then only extend, give a particular thing.
50, Lordship, interim order is there.
Minor thing, Lordship. In this.
But don't give long days.
This expression can be discussed. We have considered to the prayer of the.
No.
Maybe
Mr. Sharma, kindly appreciate. I'm not, I have a meeting. So I
And if
have,
you are day after tomorrow, we have interim order is against us. We have considered to their prayer Lordship. Actual e-procurement was done above the 20.
okay, item number
48 and 53, Lordship.
Huh?
And 53 will be disposed of.
48 to 53.
51 and 48, 51 and 53.
এই তিনটা হল পুরোপুরি লিকুইড
After tomorrow, it will be disposed of. We have considered.
55 and 56 needs to be listed within a week, Your Lordship. Item number 44, 55, and 56. The short gist of the matter is, I am a manufacturer. There was an order, Your Lordship, which stated that if I am the L1, the matter has to be subject to the outcome of the writ petition. The tender has been
Okay,
modified to
fine.
that extent.
Take it, fine.
I'm good. I'm good.
Item